regarding Bazar allotment beta. Still, the government file affidavit that the petitioner number 2 and 3 got settlements of Bazar beta. But that is not the case. That is the respondent, some other person.
Judgment has been delivered. What are you making a mention?
Otherwise,
Judgment has been delivered already.
well,
I beg to mention repetition, new motion matter, Your Lordship.
When?
Next week, any day, Your Lordship.
May I please, Your Lordship, I beg to mention, Lordship, admission hearing, Lordship, item number 13, Lordship. On behalf-
1-3.
Lordship, on behalf of TK Jain, Lordship, he could not, unable to appear today.
Water resource, have you informed the water resource department?
No.
You have to inform the department. Council will allow your adjournment prayer. Inform them first. Yes, Mr. Ali?
My lord, yesterday one matter came, my lord. The petitioners approached challenging the eviction notice, my lord. But your lordship was pleased to decline the interim on the ground that I could not produce the original agreement with the respondents. So that have been collected, my lord. I have filed one IM. So may I pray that it may be taken up today as unstated matter at 2 p.m.
Today, it's not possible. I has to, you have filed today, I has to be numbered. It can
Right.
come out on Monday.
My obligation.
My lord, I beg to mention item 27 matter.
20?
27 matter.
Yes.
We are going to produce the list of dues from the department. We have sought the list of dues from the administration also.
On a prayer made by Sri S. Singh, S. Singh, Learned Counsel for the petitioner. Matter is adjourned by 3 weeks to enable him to seek further instructions. List on 22. Please do it.
May it please, Your Lordship. I beg to mention item number 14, my lord.
1-4.
Yes, Your Lordship. I am appearing for petitioner, my lord. In this matter, I have to file reply, my lord. I am going to file today, my lord.
Okay, have you informed?
No, my lord, I will inform my
You
lord.
inform first, then we'll allow. Don't
Okay.
make a mention without informing.
May I
Yes.
please, Lordship? Item number 28, Lordship.
2-8, yes.
Kindly the matter will be taken up after 2 weeks, Lordship.
After
2 weeks. I have taken the consent from the other side.
28, 2 weeks. Yeah, for the petitioner.
I am on behalf of Mr. B. Purvachtar. Yes,
Okay.
Lordship, for the petition.
These are fixed matters. Where is seeking time? Our request has been made on behalf of Sri B. Purkas, the Learned Counsel for the petitioner for adjournment. Para? List. The matter is accordingly adjourned to be listed on 11th of February.
I am for respondent.
My lord.
Sri Goswami and Goswami Learned State Council, as well as excise. Anyone excise?
I am for action.
Excise. State Council is present.
My
Yes,
lord,
Mr. Kumar?
my lord, item 51, my lord.
Yes.
My lord, yesterday my lord had asked me to take instructions. My
Yes.
lord, unfortunately, the instructions has not come because of the ongoing parliament session, my lord.
Okay.
They have been, so my lord, we are requesting for some time, my lord, for some about 4
But,
weeks time, my lord.
This court will not be available for 2 weeks here in Guwahati.
My lord, I'm requesting for 4 weeks, my lord. 4
Okay.
weeks, my lord, because the
Then-
problem is
then
that,
it will
my
not
lord,
be treated as part heard after 4 weeks.
my lord.
If it comes before this court, easy for us because we have already heard the matter.
Yes, my lord, I quite get that, my lord. I
Have
tried
you
my
informed the
level
other
best to,
side? Who's
my
your-
lord, I'll just get it.
You're appearing
I'll just
locally,
inform.
mister?
I have not filed the Waladama. Yesterday, they have instructed us to.
No, doesn't matter. Are you assisting Mr. Kumar? You are in the.
I will inform the other side.
No, you
Yes.
have to inform them
Yes.
first. We cannot pass an order in their absence. Please inform Mr. Who was the LCD
Day.
was there. We'll grant adjournment, but not in their presence. Okay?
My lord, it may be
We'll
taken
record
after
your-
motion
record
matters,
your
my lord.
presence online, but have
Yes.
Mr. Day, please inform Mr. Day. Yes.
May it please your lordship, I beg to mention for listing of a writ petition,
Obliged.
for new writ petition for motion,
When?
next Monday, lordship.
Not please, Your
Filed or not? Have you filed?
Yes.
Yes,
May I
Mr.
please,
Bora.
Your Lordship, with the consent to with the other side, Lordship, I beg to mention item number 39.
39, yes.
39. Lordship, here we have to file our affidavit in opposition. Unfortunately, my name has not been shown in the cause list. We are.
Standing Council Excise Department is there.
Yes, we are I'm for the private respondent, Lordship.
You're for private respondent.
Lordship. It's a newly implemented respondent.
Okay. Sri, you write what, Bora?
Arbora.
Arbor, Sri Arbora. Learned Council has informed that he has entered appearance for the newly implemented respond number
6 and 7.
6 and 7 and prays for time to file the response file the counter affidavit. Para. Matter accordingly stands adjourned to be listed on 16th of February
Lordship.
to enable filing of counter affidavit. Let the name of Sri Bora be listed, be reflected in the cause list.
Obliged, Lordship.
May I please, your lordship, in respect of item number 54, lordship.
With 54 supply list.
Yes, lordship. I'm seeking for a very short accommodation, lordship. Just 1 week's time to obtain instruction from the,
Here for the petitioner.
yes, lordship.
Health department informed.
Yes, lordship. I have their consent, lordship.
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed when? Listed on 9th of February,
Very well, lordship.
9/2. Yes.
Highly obliged.
Wait, please, Lordship. Lordship, beg to mention item 37, Lords.
Yeah.
Lord, I may be permitted to withdraw this matter now. On behalf of Senior Counsel P.T. Governor, my name is
You're Jay Singh.
Jason.
Sri Jay Singh, learned counsel, appearing on instruction of Sri B.D. Kaur, learned senior counsel for the petitioner, submits that he wants to withdraw the writ petition. Also heard Sri Excise Department, also heard Sri R.R. Gogoi, learned standing counsel Excise Department, as well as Sri B. Chaudhary, learned counsel for the responsibles. 6. Para. Writ petition is accordingly dismissed on withdrawal.
My Lord, may grant me liberty also, Lord, because
What liberty?
my Lord, to approach again, because in this matter, I'm not getting instruction from the petitioner. In future, if he comes to me, my Lord, then it will be difficult now.
It is needless to state that for any press cause of action, there will be no bar to approach the appropriate forum.
Alright.
May it please, your lordship. I beg to mention item number 14, my lord. I have informed B. Gogoi, my lord.
Yes.
My lord, I have to file and file reply, my lord. I am going to file and copies furnished, my lord.
Okay, you are going to file it today.
Yes, your lord.
When do you want the matter to be listed?
If possible on Wednesday, my lord. Next.
Okay. Sri M. Sekya, learned counsel for the petitioner, has submitted that the rejoinder affidavit would be filed during the course of the day. Full stop. Para. Let such rejoinder be filed and the matter be listed on 4th along with such rejoinder. 4/2. First
Like the
rejoinder affidavit.
Lordship, in item number 42, Lordship,
Yes.
I'm going to file an affidavit, Lordship, and may it be called for.
Yes,
Lordship,
you bring.
at the time.
May I please. First, I beg to mention in matter for admission, it last listed on 18/6/2025.
Matter, subject matter, urgency.
It is concerning contextual bill. However, all similar matters have been disposed of. We required a similar order on the last occasion that when it was listed. The other side sought instruction to seek time whether it is similar or not. Since then, it has not been listed.
Why don't you file an application before the registry? File an application. Mention memos are only meant for urgent matters which cannot wait for a day. Motion, yes, motion, there is no, we do not insist on the urgency factor. But orders, admission, that is not the purpose of a mention memo. You file an application. If the registry does not do anything, then you come before us. Okay. Yes.
May it please, lordship. Lordship, I beg to mention for listing of a writ petition for orders, lordship.
Orders, what urgency?
Lordship, petitioner is a medical practitioner who has completed his BTS degree from UP. But right now he wants to enter his name in regional dental clinic.
You file an application before the registry, not a matter for out of turn listing by mention memo.
We have already approached before the registry.
When did you approach?
Lordship,
Where is your application?
2 weeks ago, lordship.
Application? Show us the application.
Right now I don't have.
You bring the application,
Okay.
making a statement will not do.
Okay.
Obliged.
May it please, your lordship.
Lordship, I beg to mention for listing on motion matter, my lord.
When?
Second, my. Fourth.
4th, make it on 4th.
IMD.
Okay.
Lordship, in this matter, we were supposed to take instruction.
Hmm.
So the executive engineer has submitted a fund demand to the chief engineer. Now, after verification, it will go to the higher authorities, your lordship. So at this stage, may I have a notice may go, your lordship.
Will you issue notice at
Very
this
well.
stage? What is your name? A. Rahman.
My lord.
Your A. Rahman, heard Sri A. Rahman, learned counsel for the petitioner who has approached this court alleging willful and deliberate disobedience of the order dated 28/10/2024 passed in WPC so and so. Full stop. This court wide order dated 12/11/2025 had requested the standing council of the PHE requested Sri R. Gogoi, the learned standing council PHE, to obtain instructions para let notice be issued. Returnable on 2nd of March 2026. Will you accept notice?
Let the notice go.
Yes, let steps be taken for service of notice upon the respondent by speed post with AD. Steps within 2 working days.
Obliged, Lord.
I didn't do. Yes, petitioner Mohanto. P. Mohanto.
Here they have filed an additional affidavit, Lordship. Perhaps this is not on record. Matter of fact is, Lordship, they have challenged the tender process, Lordship. And
Hanep, yes, you're there, madam. Yes, what is it?
May it please, Mr. Lordship, we have filed an additional and brought on record the work orders, Lordship.
Is it tagged to the record, to the court record? When did you file, madam?
Lordship,
28 probably.
yes, Lordship.
Yesterday.
Day before.
We'll have it on Monday along with that affidavit.
Lordship, it is not on record.
It's not on record.
Only thing is, Lordship,
The notice may be issued, Lordship.
No, your affidavit has been filed. Monday we'll have it. We'll have a look at the affidavit because we had made an observation that
yes.
you needed time to file the addition. We'll say that you have filed it. Okay. Pursuant to the order dated 9/1/2026, your MDAS,
Yes,
Ms. MDAS, learned counsel for the petitioner, has submitted that the additional affidavit has been filed when?
on 28th, Lordship.
28/1/2026, which however is not tagged with the records para. Register to verify and tag the affidavit with the court file and list the same for motion on Monday?
Monday.
On 2nd.
my name may be recorded, Lord.
3 and Upadhyay and standing council irrigation department
Lord.
is present.
Lord, forward. Contempt petition, the order concerned is at page 13, operative part, your Lordship will find page 15, the paragraph down below. May I read, madam? This court therefore considers it appropriate to close the writ petition directing the respondent authorities, more particularly Chief Engineer, Water Resource Department, to undertake necessary process for
Okay,
verification.
heard 3D Chakraborty, learned counsel for the petitioner who has filed this application alleging willful and deliberate so and so, ordered so and so, past and so and so. He has also drawn the attention of this court to the representation dated 1/9/2025, submitted requesting compliance of the order in question. Para, that notice be issued, returnable on 2nd of March. The last steps were speed post to TD,
Deeply,
steps within 2 working days.
deeply.
It's not
So court order, Lordship, page 20, Lordship.
20.
20, Lordship. The 11, para 7.
Para
Para 7.
okay. Similar, This is not order dated 2/12/2024, Pakistan. Where is your representation?
Representation page 14, Lordship.
Dated
Dated 16/12/2000.
16/12/25.
2005. Not 24.
16/12.
16/12/2024.
Okay. Yes, notice takes steps by Speed Post PTD. Were reckonable on 2nd of March.
Public.
Yes.
Today I have submitted the evident for settlement. The
You have filed amended cost title?
yes.
You are challenging an award.
Yes. Yes.
Okay.
Award
Or
is
CA
already-
Jahid Learned Counsel for the petitioner who by means of this petition has put to challenge an award dated 31/12/2024 passed by the Learned Industrial Tribunal Guwahati in reference case number 1 of 2023. Full stop. He has also informed that in terms of the order dated 21/2/2026, an amended cost title has been filed, which is on record. Let notice be issued, returnable on, oh, no, don't say notice, that let rule be issued, returnable on 6th of March. Let the records of the Learned Tribunal be called for. Let steps be taken for service of notice upon respondent by Speed Post TTD, steps within 2 working days.
I have Indian prayer melody. I have Indian prayer melody.
What was the award?
But award melody regarding melody payment of pension, payment of gratuity and PF melody. Yes, loss will find at page 56 melody.
Yes. What is the prima facie case you are making out?
Melody, the labor code or industrial terminal cannot go beyond the issues referred to it melody.
It was beyond the reference.
yes,
Let us see the reference.
Reference melody page 15 melody.
15.
15 melody.
Yes.
Issue melody, Lordship will say CDL.
Hmm.
Whether the management is justified in giving retirement to Srimati Josna Bhuya and Jamini Daga prematurely.
So what is the direction?
Direction melody to pay the gratuity and PF melody. The first issue is decided in our favor melody. It was justified melody. But so far second issue melody.
Three, but gratuity and PF, they are legally entitled to, but still then, okay. Sri Jahid, the Learned Counsel, prays for an interim order. Full stop. In support thereof, he has contended that the schedule of the notification dated 19/12/2022 containing of the referring the matter does not have any specific issue with regard to the gratuity and PF.
Yes.
In spite of which the Learned Labour Court had traversed beyond the reference and has passed the impugned direction. Full stop. Considering the above, comma, it is directed that till the returnable date, comma, the impugned award dated so and so shall remain suspended. Pertaining to, not your part, pertaining to the direction for payment of gratuity and PF shall remain suspended. Otherwise, their part in your favor will also go. Yes.
Article 6. Is your lordship.
Yes.
Lordship, this is a matter of non-payment of admitted dues, my lords. The petitioner herein is an enlisted class 2 contractor.
Where is the admitted dues?
Yes, my lord.
Where is the admission?
My lords, the work orders are there at my lord's page 17.
No, not the work orders, the admission, the acknowledgement of the liability.
My lords, I have instructions, my lords, that these are admitted dues, my lords.
No, that will not do. This is a writ court. This is not a civil
All right,
court.
my lords, may have a look at page 44, my lords.
4-4.
Yes, my lords.
Yes.
Well, there's an internal communication, my lord. This is an escalation letter of
Yes.
my demand, my lords, that is being made by the superintendent engineer to the office of the superintendent engineer.
That's not to demand for. But this is not by the chief engineer.
My lords, this is by the executive engineer.
There is a requirement by the chief engineer. We have to follow a full bench.
My lords, there has been no occasion for such admission actually, so I
So
don't
you
have a
you have to
document.
approach a civil court. You may have a good case. We are not saying that you do not have a case, but we are exercising 226 jurisdiction. It's not a question, it's not a court on facts.
My lords, may issue notice if they deny the.
No,
if
no,
they
it's not
deny
like,
the
it's not that simple. You have you read Tamsir Ali?
No, my
You have
lords,
to read-
I'm aware about this.
You have to
It's
read
about
Tamsir Ali,
review.
there are guidelines.
Yeah.
Your approach to a court is not barred, but your approach to a writ court is circumscribed. You have to fulfill some basic criteria. The liability has to be acknowledged by none other by the head of the department or the chief engineer in writing.
But my lords, I cannot get that acknowledgement at
No,
this
then
stage.
you approach the civil court, prove your case, get the decree. They may not acknowledge.
My lords, I have.
And this is not a,
this
this is not a court for enforcement of for recovery. It's not a recovery court. This jurisdiction we are exercising only on special cases. It's an
Understood.
extraordinary jurisdiction.
My lords, I am an enlisted contractor, my lords. I'm working for more than 20 years with this department, my lords.
Please do not make those submissions.
Yes, my lords.
Those will not have any impact on a writ court. We are not a court on facts. You may have a case.
My lords, may give me one more day, I'll satisfy my lords, otherwise I'll withdraw the case.
No, if you have a document, you put it. There's no
My lords-
question of being able to satisfy or not satisfy.
But
Your
the
doors
only
to
document that I have towards this
that will not do. That will not do. You read Tamsir Ali, we don't mind giving you
My
another
lords, this
date.
department is, I don't think they're gonna provide us with such a communication acknowledging the,
You should have got the communication, then it come to the court, not like this.
but my lords, there's no way I can get it acknowledged. from
Then
them.
you go to
I
the
have
civil
the work
court.
orders and the bills, my lord.
You have to go to the civil court.
My lords, may give me just one day, one more day. I'll try and satisfy my lord.
Okay. What is your name?
T Millie, my lord.
Hard T. Millie, learned counsel for the petitioner who has approached this court for a direction for release of contractual dues. However, on a perusal of the documents enclosed, there is no acknowledgement in writing by the chief engineer oblique HOD, which is a requirement laid down by the honorable full bench in the case of Tamsir Ali versus so-and-so report and so-and-so. At this stage, the learned counsel prays for some time to obtain further instructions if there is any such acknowledgement. Full stop. So we are Gogoi, learned counsel for the PHE is present. When we grant you 2 weeks time.
Much obliged. my lord.
Okay, list on 16th.
All right, my lord.
Obliged.
So this case also pertains to non-payment of contractual bill. Lordship, petitioner supplied stationery and IT items. to
Which
the
department?
Commissioner of Police. Police Department.
Police, where is the
That
acknowledgement?
Lordship will find that annexure 2 is the bill.
Yes,
That is the head under which the payment is to be made.
yes,
It is countersigned by the IC stationery branch. Statement, page 30.
30.
30.
Yes.
Statement showing the detail headwise for the month of August 2020 under the head 99 IT 02 and the
Will it meet the requirement of Tamsir Ali?
that Lordship, it is on the extreme left-hand side. Then
Yes.
again, it is shown payable to Messrs. Ample Commercial Computer
No.
Items
By whom? Signed by whom?
signed by the IC stationery branch of the.
He is
office
the
of
head of the department.
He is not the head. Let me get back, Lordship.
See, don't flood the red court when Tamsir Ali is there. You get a review of Tamsir Ali.
Otherwise, these are all admitted bills.
We understand, but we need to go, we have to follow Tamsir Ali. It's a full bench.
Let it come after a week, Lordship.
Okay, the same order, huh? After 2 weeks. No? Then Bokolier, A Ganguly. Then Ekke order, Bokolier is present. We have it on 16th, Mr. Ganguly. Have it on 16th. If you will grant you liberty to approach the civil court. If you get the document, we don't mind.
Lordship.
Yes.
My lord, we are the two petitioners, we are the widow and son respectively of late Putul Sharma. Putul Sharma was a farm, he is having a farm by the name and style of Prasanna Welding Industries Limited under Digboy Oil Refinery. On 12/8/25, he was found missing.
Oh, the father, your
Husband
husband.
and father respectively
Okay.
of the petitioners.
Okay.
Then we charged him here and there, but did not get any clue about his whereabouts. Then we filed an FIR before the OC Digboy PS.
Okay.
OC registered the case, perhaps due to their sources, as a kidnapping case. This Prasanna Sharma, through his industry, got various works, welding works from the IOCL
Missing since when?
since 12/8/25.
Okay, then.
Then we filed a FIR before the police on 28/8/25.
Okay.
And police registered the case and as a case of kidnapping.
Yes.
But we do not know whether he has been kidnapped or not. But police, perhaps from their own sources, got something. Then, my lord, various works were allotted to Putul Sharma regarding welding matters. Those works he completed, in some works he completed, some works was under the process of completion. So he had to get some money from the IOCL.
Mm.
But Putul Sharma did not give any, did not make any nominee in our favor. So we applied before the IOCL that the works which have already been completed, kindly pay this so that we may pay the remuneration to the workers who has completed the work, and also allow us to complete the uncompleted works, incompleted works. So there we have submitted a large number of representations before the authority, but authority kept total silence, nothing done. Rather, 2 works which were allotted to our firm have been cancelled, but without paying anything. In such a situation, we are facing different difficulties. Laborers demanding money.
Yes, Mr. Chaudhary.
And they also want to blacklist our firm. So that is our interim prayer. It may not be blacklisted because we have no wrong at all.
Yes.
My lord, with all sympathies to the petitioners, my lord, the contracts that were awarded to the, my lord, the
Reform.
farm, those have already been cancelled because of the default, not, my lord, only subsequent to his missing, but prior to that also. And there is no way, my lord, we can really help them, my lord, because
What about releasing of the balance amount? What has been,
my lord,
what?
on that, my lord, if there is any due, my lord, I have to obtain it.
We issue notice at this stage. Okay.
And no blacklisted candy.
No, blacklisting, my lord, the firm in fact does not exist now.
Oh, no.
It is a, my lord,
If
proprietary.
the proprietor is not there, the
No.
question of doing business by the firm will
That is
not
a
arise.
presumption, but till today, nothing wrong has been discovered with us.
No, no, Mr. Mahmood, that is not the issue. If suppose you want to participate in a tender process in the name of this firm, where the proprietor is not there, let us assume that he's there, he's kidnapped, he's not dead, he's alive. But who will do the needful in applying,
We
signing?
have submitted representation along with affidavit and indemnity bond that will indemnify the IOCL if any work.
No, no, how do you apply in the name of a firm whose sole proprietor is not there?
For that, we will produce necessary papers if necessity arises.
No, who can represent a firm? A sole proprietorship firm in absence of the proprietor.
That is
If had it
true,
been a partnership, matter would have been different.
but my lord, everything is for the answer.
Okay, yes. No,
At least no coercive measure may be taken. What they have already taken, that is another matter. In future, no coercive measure till the matter is.
what do you gain by blacklisting? There is no question of blacklisting.
The firm is not in existence.
Firm may not be in existence. So you restrain advice.
In fact, my lord, that is my instruction is that blacklisting is in process. My lord, they have to be given,
Yes.
he has to be given notice. That has been given, my lord.
See, if the sole proprietor has actually gone missing or kidnapped, for which the works could not be progressed, blacklisting may not be right direction.
My lord, the interim prayer he has made also will not be of any help to him.
But suppose tomorrow he comes back. The police is successful in retrieving him, recovering him. Because police has registered as a kidnapping case. Let us think positively.
Yes, my lord. Even then, my lord, he can then apply that since I was missing, I could not.
Blacklist, don't blacklist. Okay, heard Sri M.U. Mahmood, Learned Counsel for the petitioners. Full stop. The petitioners, who are two in numbers, are the wife and son of one Prasanna Sharma,
No, let Putul Sharma.
Putul.
Putul Sharma. Let means Putul
Don't
Sharma.
say late.
No, no, no. No, I am not saying that.
You are saying
No, no, that is my due to bona fide mistake, man.
bona fide. One Putul Sharma, who is the sole proprietor of Messrs. Prasanna Welding Industries and was engaged in various works with the IOC L, Digboi. Full stop. The sole proprietor had, however, gone missing on 12/8/2025, for which an Ejahar was lodged. Full stop. The police had, however, registered the FIR under the as a kidnapping case on 28/8/2025. Full stop. The grievance of the petitioner grievances of the petitioners are with regard to non-release of works done with the IOCL and also on the apprehension that
Not allowing us to do further work.
not allowing the petitioners to continue the existing works, and also with an apprehension that the firm in question may be blacklisted. Let notice be issued, returnable on 20/20. 22. Mr. Sharma will be Sri M. Sharma, Learned Counsel assisting Sri M. K. Chaudhary, Learned Senior Counsel, accepts notice on behalf of
2 to 7.
or CGC is there. Or the B. Sharma को लिखना. Please B. Sharma CGC for 1. M. Sharma assisting so and so 2 to 7. Extra copies. Sri Mahmood, the Learned Counsel, prays for an interim order. Full stop. The same is, however, opposed by the Learned Senior Counsel for the IOCL. Full stop, para. Since it is not in dispute regarding missing of the sole proprietor from 12/8/2025, for which an FIR is also registered, this court is of the opinion that taking a recourse to blacklist the firm would not be in the interest of justice. Full stop. In view of the same, no steps be taken to blacklist the proprietorship firm till the returnable date.
Well, okay.
All right.
Please.
Mr. Datta?
In 2019, a tender process was initiated for allotments of some shops at the Alkapur Gaon Panchayat. And the petitioners the highest bidders page 36 and 37 serial number 2 and 3 and serial number 17 on page 37.
Oh.
Now thereafter this was embroiled in some litigations. In fact, your lordships had passed an order.
Yes, remember.
Thereafter matter went to the
Supreme Court, yes, sir, also remember.
Then on 27/3/2023, some similarly situated persons were given the allotment of the and agreements were entered into. But the allotments of the shops were not handed over. And finally on 14/10/2025, shops were handed over to these other persons. So the petitioners have been left out. And the only reason has been verbally communicated is that they are the highest bidder, but they are the single tenderers. But there is no such condition the tender.
With single tender, you cannot proceed. There are CVC guidelines.
But
has any other tenderer who was a single tenderer been given the rooms? Can you cite any other case similarly situated?
I think one tender, of course. But after
okay, we'll issue notice at this stage. Heard Sri M. Datta, Learned Counsel for the petitioners who are aggrieved of non-allotment of shops by the Which panchayat?
Algapur Gaon Panchayat.
Algapur Gaon Panchayat pursuant to a tender process which was initiated in the year 2019. Full stop. The learned council has contended that there have been series of litigations which went up to the Honorable Supreme Court, whereafter a process was initiated and the highest bidders were allotted the rooms. Full stop. However, the petitioners were left out in the process in spite of being highest bidders. Para? Let notice be issued, returnable on 16th of, not 16th, 23rd of February 2026. Yes, we'll accept notice, Mr. Vokolia.
I'm only for response number 2.
Two.
Yes, madam.
Yes, Mr. Datta. Panchayat.
Yes.
For Datta for 1, 3, 4 also.
Yes, madam.
And 5?
5 also, madam.
Algapur Gaon Panchayat representatives have 5 also. 1,
Yes.
1,
1,
3,
3, 4,
4 and 5. Datta and G. Bokolial and the State Council for 2 extra copies.
Well, interim payment will be also done.
What is interim?
Formula not allotment, not a non-allotment shop to other persons, madam, any other persons.
Sri Datta, the learned council prays for an interim order. Full stop. This court is, however, not inclined to pass any blanket interim order. Full stop. It is, however, observed that allotment, if made in favor of any other person, shall be subject to final order, subject to further orders that may be passed.
Hello.
May I please, your lordship.
Yes.
And a petitioner was awarded to make a buy picture, my lord, at the rate of 42 lakhs. Again, accordingly, that was done and that was submitted to the Department of Cultural Affairs. Only 16 lakhs 80,000 was released. After that, my lord, the balance amount had not been released. Your lordship may turn to page 13, Annex 1, my lord.
1-3.
1-3, yes, my lord.
Yes.
Financial down my lord, financial section of the competent authorities hereby accorded for an amount of not exceeding 42 lakhs towards the payment of the subject to the following terms and conditions. My lord, that time what happened, my lord? Legible copy was not. I have not got it, man. Subsequently, I have given you a face copy, my lord.
Well, you have given a type copy. Is there? Page 13.
Yes.
13 is the type copy.
Yes, my 13 is a type copy. Then these are the terms and conditions.
Okay.
Terms and condition, my lord. There is nothing much, my lord, in the terms and condition. And subsequently, your lordship may turn to page Annex 3, my lord, page 18.
Yes.
Then subject of submission of the final print copy of the documentary on Abutoni Devi Lota, Paramananda Atwine. Accordingly, my lord, with reference to the subject cited over, you are directed to submit a final print copy of the documentary on Abutoni Devi Lota, Paramananda Atoi Niketan in Assam, so and so. You are also directed to collect the receipt of the document from the Assam State Film Corporation Limited, submit the same to the undersigned. Accordingly, when the same was submitted, that is in paragraph Annex 4, my lord.
Yes.
With reference to your letter so and so, here is submitted the final copy of the above subject mentioned film pen drive at your office at the Assam State Film. Accordingly, my lord, your lordship will find it down below, they have received it. Then subsequently, my lord, what happened? He was having a loan with the net fee. Then there is no relationship with this loan. And my lord, the Department of Cultural Affairs, they are trying to release the amount to the net fee. And subsequently, what happened? The net fee wrote a letter to them to release the amount to them. And this is your lordship will find Annex 7. Annex 7 in the net fee, so and so. That is balance amount 25 lakhs 20,000 so and so. But your lordship is subsequently find in Annex 6. Annex 6, my lord, that is in page 24. There is no relationship, my lord. The RTO was.
But you had filed an earlier writ application.
Yes.
There is an order passed by this court.
Yes, my lord.
Yes.
That order was passed. I don't know what happened. And that order was finally not disposed of, your lordship may turn to page 28. Page 28, my lord. Has your
No, but
lordship?
you had withdrawn the writ petition earlier. writ
That's, I don't know, something happened, and something happened actually upon the petition was withdrawn. But this is the observation. Your lordship will find the observation at page 20.
No, if you come to thereafter to page 29.
Yes, my lord.
29, you have withdrawn, you have to.
Yes, some of the reason it was, I don't know what
You have to
something
file a
happened in
review, you have
between.
to file a review. How do you file another writ petition which was withdrawn? You file a review, will allow the review, will have the writ petition adjudicated. After withdrawal, you cannot file another writ petition. You may have there may be a wrong instructions.
Yes, there may
You may
some-
be correct in
something,
content.
there is no reason.
Hmm.
Observation was made by this
But
honorable.
when till this order is there of withdrawal without any liberty,
Yes, my lord.
we cannot perhaps. You file an application for revival of the earlier writ petition. You can take support of this. But this will not be a proper course of action.
Yes, my lord. Then liberty may be
We
given,
will-
the observation may be made. my lord.
Granted.
Yes. my
Heard 3, Mr. Bukolian. Heard 3, Y. Doloi, the learned counsel for the petitioner. Also heard 3, G. Bukolian, learned state counsel.
My
For
lord,
the-
my lord, but earlier, but Challenger is something different. Challenger is different, we have challenged it, money should not be directed to the net fee.
Yes,
Now the balance payment is not made. This is the difference of the payers. my lord.
but the money has already gone to net fee.
No, not yet, my lord. Money is not yet gone to the net. It is with the cultural affairs.
Huh?
My lord,
Money is not released to the net fee, my lord. Till today.
Okay, heard 3, Y. Doloi, learned counsel for the petitioner. Also, as per the facts projected, the petitioner was entrusted to produce a biopic documentary on Abu Tani Dirbi Lota, Parabananda Atoy Niketan, infrared
yes,
council.
ma'am.
By the response number 3, for which there was a financial sanction, full stop. However, even after completion
And
of
my
the
amount
work
may be mentioned 42 lakhs. Financial section of 42
for
lakhs.
rupees 42 lakhs, full stop. However,
Only 16 lakhs 80,000
However,
was released.
only a part thereof being 16 lakhs, 80,000
Was released.
was released, and the rest of the amount has not been released. Full stop. Para. He has also submitted that in the meantime, there was a move to divert the amount to the net fee, for which the petitioner had earlier instituted WPC 207 of 2025, which was however withdrawn on 30/5/2025. Para. Will that notice be issued?
no,
Returnable on we'll have it on 5th on 6th of March.
My lord, can it be the month of February, end of February maybe, my lord, because accounting is closing on 31st of March.
Okay, then 25th February.
25th February. yes,
25th February.
Yes.
Bukolial for
1, 2, 3.
1, 2, and 3. And Finance Department,
Yes, sir.
I'm here for extra copy. Please give the.
Yeah, wait, course of the day, my lord. Obvious.
You can take this back. Mr. Dolo, you can take this document.
Yes, ma'am.
Item number 48.
May I please your lordship, my lord?
Yes.
In this case, my lord, there is a history, my lord, background. A plot of land, my lord, 63 acres in odd land was requisitioned, my lord. A plot of land measuring about 63 acres in odd land was requisitioned by the government, which belonged to the grandfather of the petition,
63 bighas
my lord.
requisition.
My lord. That land was actually belongs to Kamakha Devi at Mandir Trust, and it was allotted to the grandfather who was the Devu of the Mandir. Then, my lord, after the
Now,
requisition,
if the deity owns the land,
my lord,
how does your grandfather
because it was allotted, my lord, he is the Devian priest. There, my lord, there is a procedure, and in terms of that procedure, those who are the priest of the Mandir, they were given some allotment.
allotment is okay, but the deity remains to be the owner. How will the ownership change?
Devdi means, my lord, so far as the Devdi is concerned.
No,
they are
no, the
priest of the
deity.
Deity.
Deity will remain the owner. deity is the legal
And that
entity.
was, my lord, allowed to be possession occupied by all the priests at that point of time. Now, about,
Now,
my lord,
what is your grievance now?
my lord, now 16 because land remain, my lord, unused. Then the grandson, the present petitioner, he approached the authority and made an application for allotment. My lord, 1 katha and 2 katha and odd land. And that was processed. At one point of time, my lord, they kept the matter pending without any communication. Then I made representation. They did not give any reply. I made an application for RTI information. They said application is rejected. So this is the case. So at this time, Lordship may kindly issue notice.
So where is your right to
That's
get
not-
allotment?
It's no right. Even then, my lord, the land which was.
If you do not have any enforceable right, how do
Right.
you approach a writ court?
The land menu which was not used, remain unused. They were allowed to be occupied by some other person. Because I made elaborate statement in my application. Annexure 8.
Mr. Purkast, a difficult proposition.
And on the other hand, I don't know any compensation was even paid to us. So far as my instruction goes on. At least, my lord, they apprised the court. That this is the reason we could not consider your.
Mr. Gogoi?
1969 land was acquired, Lordship.
Huh?
1969 land was acquired. Where with 1969 years?
No, he's not on the, against the acquisition of
Yes,
land.
yes.
He says the 16 bighas are
Lordship.
still unutilized. He wants allotment of a particular area of the 16 bigha.
That part, Lordship.
We have not been able to see the source of your right.
That's right, that's right.
If that is right, why have you filed this case?
At least, my lord, there to give some reason, my lord, we could not, my lord, consider your case. You are allowing someone to occupy the land. Now I made in, my lord, bona fide application.
Difficult proposition, very difficult.
Even then, my lord, at least they are to apprise the court, my lord, what is the reason? Because I have a right to know the reason. In spite of the fact that I.
First, you have to establish a right of yours to get allotment of land.
My lord. Anybody may.
You are a landless person.
I'm a landless person.
Where have you stated?
Yes, my lord, I've said. I've stated.
Where have you stated? Let us see.
My lord, just a minute, my lord.
And these lands perhaps belong to the devotor.
Devotor.
Then devotor land, how do you get allotment?
Number of my lord, Kamakya Mandir temple, priest, number of priests, my lord, they are holding the land belong to their.
You're a priest.
My grandfather was a priest.
No, are you?
No, I am not a priest.
Then
I am not a priest.
you are neither a priest, nor you can show any right for such allotment.
At least, my lord, right to be considered.
Now, where is the statement that you are landless? You are entitled to be considered for allotment?
Lordship, total 70 paragraph is there, not a single paragraph is there.
Yes, I have made. Because I have to bring on record the entire, my lord, history, what is the background of.
What, 17?
Total 70 paragraphs is made. Lordship.
Only 70? For Mr. Purkasa, 70 is less.
It is a talk of the day.
He scores century
It is talk of the day.
normally.
My lord, give me, my lord, 2 minutes time, my lord. I'll find it out. Just, my lord, just a minute.
You take not 2 minutes, you will take 2 weeks. We come
Oh,
back on
that's your lordship.
16th.
Yes, my lord. I made, my lord, statement that they are landless persons.
Heard 3 AK Purkasa, learned counsel for the petitioner. Also heard 3 K Gogoi, learned CGC for the para on a specific query regarding the enforceable right which the petitioner claims for allotment of land belonging to the devoter, Kamakya devoter, the learned council has prayed for some time to take instructions, para. Place for motion on 16th.
Fine. Only to the extent that whether I am landlord person or not.
Should we mention that there will be no bar for withdrawal of the writ petition on the writ, on the next date?
Lordship will consider on 16th.
Okay. There is a scope of withdrawal. Okay, next. 49. Taken. It's a similar or what?
Which one?
Similar petitions, both
Somehow.
Yes.
identical.
Similar.
Okay. Which should you take, Mr. Das?
My lord,
434.
434. Item that 48, no, 48. 49. 49, sorry, 48.
Which one?
49, 434.
Okay.
The first. Factually, my lord, let me be very honest to you. Factually a bit difficult. Let me tell it very openly. I have to tell my lord before this court, but this is a second round of litigation. First round of litigation, I have approached this honorable court. First round of litigation.
Yes.
And if your lordship kindly see the order of this court in the first round of litigation at page 181.
181.
181. Paragraph 187 at paragraph 12. 187, paragraph 12. Lordship, what is paragraph 12?
Yes, please.
In the above factual backdrop, let this court note down the submission on behalf of the respective party. Learned senior petitioner submitted petition have invested huge sums of money pursuant to submission of bid and the issuance of letter of acceptance. Respondent authority cannot arbitrarily and unreasonably delay the issuance of work order or enter into agreement if reason exists to deny the work order or enter into the agreement. The respondent authority ought to have been promptly informed the petitioner. However, the same have not been done in spite of almost 2 months expiring upon after issuance of LOA, which necessitate the petitioner to submit a recommendation in respect. All the respondents are silent. I participated in the bid process.
No, you kindly narrate the facts. What are the facts, background facts?
My
There
lord,
was a
there
tender
was
process.
which was issued
Hmm.
by the Indian Oil
LCL.
Corporation for this is regarding bulk LPG transportation contract by road for state of Assam and Meghalaya. Right, my lord? There
Yes.
are two bid systems. One is technical bid and one is financial bid.
Hmm.
Now, if your lordship looks into the NIT
Yes.
and which is at clause 51, clause page 51.
Page 51.
Yes. See the bidders at clause 2, my lord. First, lordship got it. Offers may be submitted by one proprietorship firm, individual.
Page 51.
51, 2
51 to bidders.
bidders.
Yes.
Offers may be submitted by proprietorship firm, individual, HUF, or Indian citizen who have attained the age of majority. This is one. Or 2 is now your lordship, please mark this, where it is registered partnership firm, registered with Register of Firm, Ministry of Corporate Affairs, consisting of Indian citizen. So what you require, my lord? Registration partnership firm, which has to be registered, and they want that it should be registered with Register of Firms. I think I am clear, my lord. This is what they require. Now, the 3 and 4 may not be applicable in the present case. Now, see next, the above constitution, the next, after 4, immediately
yes.
after 4,
Yes.
above constitution of bidders would be valid on a closing date of tender. Unregistered partnership firm, so and so will be rejected. So here, it is a registered partnership firm. Unregistered, we are not unregistered. As of date, we are registered, my lord. Kindly note that as of date, we are registered.
Yes.
Now what they rely at page 56, my lord. What they rely page 56, that this is one of the mandatory clause. So you don't qualify
under this mandatory clause.
You had participated in the bid process
Yes.
and has been rejected.
No, technically qualified.
Technically,
Financially also, LOA has been issued. LOA issued. Work order they were not issuing. I came to the court.
therefore you had come to the court on the earlier
Earlier
occasion.
occasion, I said why work order has been not
Now,
issued.
what is the difficulty now?
There the court said you bring what is your instruction? At 2 o'clock they brought an instruction in the court which is now placed in the instruction. What they said, there's a registration of pre-qualification bid. Only you are aware of it. Certificate, registration certificate was there. You have not submitted at that relevant point of the. Also after that, what was requirements? Please see page 56, my lord.
No, what is your grievance?
My grievance is that my LOA has been issued to you.
Correct.
One stage. Now you did not issue the work order.
You had come before this
You
court.
have come before, we have come up before the court. We have a partnership deed. But as on date today, I have the certificate of registration. And in that clause 4, what you said, my lord, that only there is a clause. This is important, my lord. Please look into page 56, 4. I'll just read 56, 4, my lord.
Yes.
This is important, my lord. Why they did not consider? Copy of, your lordship, copy of registration certificate 4. Copy of registration certificate from register of firm to establish the registered partnership from firm, enclosing all annexure wherein name of all partners with said partnership firm are mentioned, or certificate of incorporation wherever applicable. Now important. Bidders who have applied and are waiting for registration certificate have to furnish the necessary acknowledgement slip and proof of deposition of requisite fees to the authority. So on the date, it was not necessary that certificate of registration was required. What was necessary was only an application.
Okay.
Correct, my lord. So what I am saying, that till LOA issued, this was not a mandate, it was only an ancillary clause. It is not a mandatory. So now what they say, my lord.
No, it's a mandatory clause, but your bona fide could be ascertained if you can show that you had indeed applied for the registration of under the registrar of firms. Because there are two concepts. One is getting the partnership indeed registered. That's a different aspect.
Yes.
And one is the getting the partnership registered under the registrar of firms. They require that you should be registered. It not only has to be a registered partnership deed.
Yes.
The partnership itself has to be registered under registrar of firms, which you did not have at that time.
Yes. Right.
You are trying to make out a case that even on a case where you had applied for, not got the certificate,
Subsequent.
then also you would be considered.
Yes.
And you said that you were considered, LOA issued, and for not giving the work, you had come before this court. Now they are taking this ground.
I'll take one more, my lord.
Yes.
Factually, I have to be corrected.
Yes, yes.
My lord, at the time, when I applied, when I submitted my bid, I didn't apply for registration, certificate of registration. I applied subsequently. They checked everything, all documents was in proper. LOA has been issued, work order was not issued.
When did you apply? When did you apply
Yes,
for the
I
registration?
applied 4th of October 2025. LOA issued on 16th September 2025. So they did not tell me anything up to 4th of November. 12th of November, they did not say anything, neither they have issued a letter to me. When
What happened on 12th November?
I write to them, my lord will kindly see 12 November, which is the page. 190, kindly see, my lord. 178, my lord.
178.
Yes. Yes. This is what I have written on 12/11/2025.
Yes.
So I written to them on 12/11/2025, but there is no reply from their side. Even I have written to them, and in the meantime, I got my certificate of registration. What I am on, my lord, they now are, after the High Court's order, it went before 7. Now there is a impugn order that has been.
What was the order of this court?
Or this order of the court, they will consider, they will decide. My representation will be decided within 15 days. That was the order that was passed.
Now, at the time, when the matter was taken up, before this honorable court, on the day when the order was passed, definitely they had the instruction. Now, the instruction which was placed and now the decision which has been taken by them is totally contrary. What they say, my lord, those technical committee person, they doesn't have that legal knowledge. So that's the reason why they have considered. That's what they said. Kindly see, my lord, at page 31, my lord. Kindly 2 line I will show page 31. 30, page 30.
30.
30. Reasoning and order, see page 30. Impugn order at page 30. The impugn order after the High Court's judgment, they within 15 days, they decided and it went against her.
Page 30.
Page 30, kindly see down below.
Yes.
From IOCL conduct, it appears that the requirement of having the residence certificate was duly pointed on RDS 14(6). However, there has been a confusion created caused by production of registered deed of partnership, accompanying the application of partnership, creating a reasonable confusion of being a document reflecting on the registration of firm. Specifically, now kindly see, as the scrutiny committee team does not essentially consist of people with legal background, knowledge, the chain, now this is saying they did not have. So your entire process itself was bad then. They did not have that knowledge. The chain of events and conduct indicate cannot be construed that IOCL was inclined to waive of the essential tender condition of residence certificate from register of firms. My lord, now what they can, my lord, only my humble submission, let them produce the record to find out what is that chain of events and conduct. Secondly, what they are saying, suppose we waived you, then violation of 14, what about the other bidders? What about the other bidders? Who are other bidders that is affected? You have to come to the court, tell the court, these are the other bidders who will be affected. These are the chain of events. Today, as on today, I am having, you have scrutinized everything. Today, you are making a different story by rejecting it, saying that no, you don't, because the team doesn't have that. The scrutiny committee doesn't have that knowledge, legal knowledge. 69 of the your lordship is absolutely correct. 69 of the partnership deed, 69 of the partnership act. Now, if your lordship looks into 69 also of partnership, my lord, what is the effect? I have the deed of partnership is registered, certificate of registration, residence certificate. My lord, the Indian corporation can sue against me. I cannot sue. That's only difference, my lord. So they will be advantageous position, not me. So my
No, Mr. Das, we'll perhaps not go into that question.
Yes.
Because there is a big distinction between a registered firm, a partnership deed being registered, and the firm being registered under the Register of Firms. They require your firm to be registered under the Register of Firms, which admittedly was not there. But nonetheless, your bid was considered to the extent of grant of LOA. And only when the order was not coming, you had come before this court. And now they have realized that you did not possess a document which you admit, but you say at the same time that in the meantime you have rectified, you are now in possession of that.
Absolutely, my
So,
lord.
and in the financial bid, was there a competition?
Yes.
There was a competition.
Yes, yes,
You emerged as the
yes,
highest bidder.
Yes, yes.
Mr.
Now, I
Chaudhary,
take your seat, my lord. This is what come out from your lordship. That's your lordship was put in a very.
yes, Mr. Chaudhary.
My lord, so far as your lordship's last query is concerned, my lord, the advertisement, the NIT was issued for my lord, my lord.
Mr. Chaudhary, on the legal aspects, we are very clear. On the last date of the advertisement, he should have been equipped with all the documents which he did not.
My lord.
But this is a slightly touch and go case. You proceeded, maybe on a wrong presumption.
Wrong presumption.
Yeah, and there is no estoppel in law. You may we can anticipate your argument. If some officer has done a wrong, it will not bind your corporation. And you have also explained that they thought that deed partnership being registered is equivalent to registration under the Register of Firms, which is different. You may have a good point, but in the meantime, you have proceeded a lot. And from the perspective of public interest, he has emerged as the highest bidder.
No,
And
it's
14
not a question
perhaps will not come because
it's not a question of highest bidder, my lord. There are, my lord, as many as 814 bidders and my lord, 113 rejected, and 701, including the petitioner, was held to be technically
Yes,
qualified.
yes.
And the, my lord, orders have been issued, my lord, all the orders are now complete.
Hmm.
And your lordship will also kindly notice, my lord, there was a date when the work has to be started. And my lord, he had applied for the registration of the, under the firm, registration of the firm under
Mr.
the.
Chaudhary, you did
after
not,
that.
you need not argue on this. We are very clear. He did not procure, he did not, well, he was not in possession of a certificate, of a valid requirement on the date which he ought to have.
My lord.
This is Mr. Das has admitted.
My lord,
But in the meantime, you have proceeded.
yes,
so
my
how-
lord, but at the same time, my lord, the clause in the, my lord, in the NIT, that is not under challenge, my lord, that is a mandatory clause. We cannot go beyond that, my lord. The confusion the petitioner had regarding the, my lord, registered deed and registered firm, the same confusion.
Mr. Chaudhary, we are just repeating, we are trying to balance it. If you go very technically, you have a point, we are not saying. And you have a very valid point. Requirement to have the firm registered under registrar of firms is a requirement, mandatory requirement under the clause.
My lord.
He did not have that requirement.
He doesn't
Your
have-
officer thought that the partnership deed being registered, it conforms to the requirement.
That is what
They
is
proceeded.
included for us.
That may not bind you, but will on an overall basis, since he had emerged as the highest bidder,
It's not a question of my lord, highest bidder, my lord, those who qualify, my lord, technically. It's not a question of highest bidder.
then how was the work, the letter of
My lord,
acceptance?
the participants, my lord, the 701.
Mr. Das has said it's a two-bid system.
My lord.
So if-
Technically qualified, my lord.
Technically qualified.
Technically qualified.
Now,
That is-
what is the next stage?
Qualified. Finance, why LOA will be issued? Financially qualified also.
Maybe his financial deed was found to be.
Allow, if your lordship kindly sees the, my lord, LOA, my lord, also gives a, my lord, condition which, my lord, binds him to, my lord, provide the documents. He could not. If your lordship kindly comes to the LOA, that is a clear clause, my lord, these documents are to be provided. In fact, till that time, my lord, he even did not apply for registration. If your lordship kindly comes to page 171, that is the, my lord, letter of acceptance, then,
What is the nature of the work which was about to be allotted to him?
my lord, this is.
No, the work is for transportation of bulk LPG, that we have understood, but this will be segregated. Maybe one part or what? You said 171, 7 out of 701
Yes, yes, my lord, and 701, my lord, all
were
the-
found to be technically responsive,
and all the trucks have been, my lord, allotted of these.
divided amongst
Yes,
themselves.
yes.
I 1 4 is 1, I 4 and 1 is 10, 14. It is divided, all divided.
Presently, how are you maintaining this work? How are you doing this work?
Well,
Transportation work?
others have been given, my,
Hmm?
other bidders.
No,
have
for
been-
the route which the petitioner, the LOA in
That has
favor
been given to some others, my,
already.
yes. If your lordship kindly comes
Where,
to
where,
page.
where have you have instructions that is
I have
given to others?
instructions, my lord, I can produce those instructions, my lord. This is only verbal instruction.
Okay, then we'll have this for admission hearing. We'll dispose this of on a date which is agreeable to both of you.
Now, only one thing, our instruction, my learned friend instruction, it was given. Our instruction, this 14 has not been given to anyone. That's my instruction. Your lordship can put it on the basis of the instruction given by my
Okay.
client. This is his instruction.
Okay, okay.
It is not been given.
My lord, my answer instruction is that no vacancy remains for allotment.
Okay.
That is the instruction.
No, no, Mr. Das has been very fair in informing the court
Right.
about his weakness. He did not. He said that even after he had applied after the last date.
After the last date,
After
my
that.
lord, after this, my lord, the document was, LO was issued and asked, he was asked to
He-
produce documents. If
He applied on 4/10/2025, LO was issued on 16/9/2025.
Yes, my lord.
That's a fact.
Maybe he was happy LO has been issued, what is the requirement to register myself?
So this confusion he had, the same confusion also had with.
If
his-
your officers can have the confusion, he is a mayor, he is a citizen.
Well, he's a contractor, my lord. He has to go by
Mr.
a-
Das?
Yes.
Mr. Chaudhary is saying that you might have had some confusion. When their officers were confused, it's very much possible for you to be confused.
Yes,
Other contractors are not confused, my lord.
They are smart.
Only two contractors, my lord, they are
They've been advised by Mr. Chaudhary.
Yeah, other contractors, are-
Smart.
my lord, other contractors are very smart.
The LOA was, my lord, provisional, subject to fulfillment of these requirements.
If you have not given, please do not give to the next
That's
date.
all. Yes.
Please.
My instruction is.
We'll record here.
Oh.
Heard Sri D. Das, say, next case is the same.
Same.
Heard Sri D. Das, Leonard, Senate Council, assisted by
C. Garg.
Huh?
C. Garg.
C. Garg, Leonard Council for the petitioner. Full stop. As per the facts projected pursuant to an NIT issued by the IOCL for transportation of bulk LPG by road in the state of Assam and Meghalaya, the petitioner had participated. Full stop. The process was a two-bid system, namely technical bid and financial bid. Full stop. The petitioner is a is a partnership firm. The petition number 1 is a partnership firm, and there is a requirement to submit the registration which the registrar of firms, which admittedly the petitioner number 1 did not submit, as it was under the impression that the same relates to a registered partnership deed. Full stop. Nonetheless, the petitioner number 1 was held to be technically qualified, which is reflected from issuance of an LOA on 16/9/2025. Correct, 16/9?
Yes, yes.
Since the subsequent work orders were not forthcoming, the petitioner had approached this court by filing WPC number so and so, in which there was an order dated so and so for consideration of their case and pass appropriate orders. Full stop. The same had culminated with the impugned order dated 5/1/2026, whereby the offer has been declined on the ground that the petitioner had failed to fulfill the essential criteria of submitting the certificate of registration under the registrar of firms. Full stop. Para. Sri Das, let notice be issued, returnable on when? Next date will go for disposal.
Yes, my lord, your lordship will give us 4 weeks time, my lord.
Oh,
Because he
but
said
you
it-
filed your response
My
by
lord,
4 weeks. Can you have a 19th? 19th is a Thursday, or 24th?
24.
24th. 24th. Sorry, Mr. Sharma, is they having notice? Union of India is there. Miss M. Das Leonard, Council appearing on instruction of Sri S.K. Mehdi CDC for 1. M. Sharma assisting Sri M.K. Chaudhary, Leonard Senior Council for 2, 3, 4, 5, and 6.
6.
Extra copies. Per Sri Das, the Leonard Senior Council prays for an interim order. Full stop. He has fairly submitted that the that it is only after issuance of the LOA, when the earlier petition was instituted, the aspect could be clarified, and accordingly an application was filed on 4/10/2025 for issuance of the certificate by the registrar of firms, which has subsequently been done.
Yes.
Full stop. He has submitted that as on today, the petitioner number 1 is equipped
Yes.
with such a certificate, and therefore no illegality would be there in allotment. No irregularity or illegality would be there in allotment of the work, and in that view, the impugned action is unsustainable in law. Full stop. Para. The interim prayer has been strenuously resisted by Sri Chaudhary, the Learned Senior Council, by submitting that the impugned order has been based on relevant considerations as it was mandatory on the part of a bidder to submit such a certificate, full stop. He has also submitted that there were a number of bidders, and after the scrutiny, only 701 number of bidders have been found to be technically responsive. Full stop, para. After hearing the learned counsel for the parties and by balancing the equities. All right, huh? He has, Sri Chaudhary has also added that as per instructions, comma, there is no balance work to be allotted further. Full stop, para. After hearing the learned counsel for the parties and on balancing the equities, comma, it is provided that if the work, if the scope of the work which was within the ambit of the LOA earlier received to the petitioner has not been adopted to any third party in the meantime, comma, status quo as on today be maintained.
Yes.
Till the next date, full stop. This
Hello.
court also clarifies that an endeavor would be made for disposal of the writ petition on the next returnable date before which the pleadings are required to be completed. Same order.
Yes, sir. Quickly of them.
Your Lordship, I am appearing on behalf of Mr. G.M. Loskur. I have been informed, Your Lordship, the petitioner has expired in the meantime, Your Lordship. So I have to go for substitution, Your Lordship. But problem is that his legal heirs are residing overseas. So sometimes.
We'll close this. We'll give you liberty whenever they come. Otherwise, it has been abated. Abated. Whenever you come, we'll give you, we'll take that observation, okay? Sri R. Muzumdar, learned counsel appearing on instruction of Sri
J.M.U. Loskur,
I think this is item number
10.
Oh, this is orders, no steps.
No steps. That's why.
Okay, then first to write. This matter has been listed under the columns. Orders, no steps. Full stop. Peruse the order dated. Peruse the office note. Peruse the order dated 28/8/2025 passed by the learned Lazima Court, followed by the office note dated 12/11/2025, which reflects that steps for service of notice upon the respondents have not been taken. Para. Sri R. Mazumdar, learned counsel appearing on instruction of Sri J.U.N.M. Laskar has, however, submitted that the petitioner has expired in the meantime and the legal heirs are not readily available. Full stop, para. In that view of the matter, comma, this court is of the opinion that in absence of an application for substitution which ought to have been filed in time, comma, this petition will not be this petition cannot survive. Puts the para. Accordingly, petition is closed. Puts the, however, liberty is granted to the legal heirs to file appropriate application for revival of the same, if so advised.
Much obliged.
Please allow.
Yes, Mr. Chakraborty.
My lord, as per the last order, Lordship had directed the registry to issue reminder to the Labour Court for the records of reference case number 3 of 17.
It has come.
No, my lord. Lordship, the office note says reflect that reminder was issued to Assistant Labour Commissioner Dibrugarh. So definitely, my lord, it is not the Labour Court. Commissioner, Assistant Labour Commissioner and Labour Court are two different. Office note of perhaps 4/7/2025.
Order dated 14/3/2022.
I heard Sri S. Chakraborty.
My lord, if your lordship permits this matter without the Labour Court record, lordship can be able to
No,
dispose.
but the record will be necessary.
Because the issue was,
Mr. Chakraborty, both of you agree, then we can take that recourse, but if madam is not agreeing,
Record may be
and
necessary.
since an order was already passed, we'll clarify this. Heard 3S Chakraborty, learned counsel for the petitioner, as well as Miss A. Bhattacharya, learned counsel for respondent number 2. Para. This court, wide order dated 30/5/2025, had directed the registry to give immediate reminder to the learned labor court Dibrugarh for transmission of the relevant records. Full stop. Para. Office note dated 4/7/2025, however, would reflect that such communication was not made to the learned labor court but to the office of the Assistant Labor Commissioner Dibrugarh. Full stop. Para. এটো কি এইবিলাক কৰে? The registry is directed to issue reminder to the appropriate authority, namely the Learned Labor Court Dibrugarh, for requisitioning the record as mentioned earlier. Full stop.
Lordship may observe reference case number 3 of 70, otherwise the registry may.
Record for reference case number 3 of 17. Full stop. Para. List on, we give a date.
My lord.
On 25th of February.
25th of February.
25th of February, along with the records. It will
My lord, that is 25th is not a hearing day, my lord. Since
let us see if the records come, then you can immediately fix. That is the purpose.
My lord. Oblige.
Mr. Kaushik, please.
May please, Lordship. Lordship will kindly peruse the order dated 2nd of February 2022. Madam. There was a direction to the circle officer to clarify the contradiction, and the affidavit has not been filed yet, madam.
But somebody has filed affidavit, R5 has filed,
Respondent number 5 has filed.
4 and 5
There-
have filed.
There were two directions, my lord. One to the respondent number 5 to file an additional affidavit to bring on record certain documents. They have brought in, but the circle officer has given two reports, my lord. In one report, he says it is a land.
Yes, what do you say?
Yes, my lord. An affidavit has been filed, my lord, pursuant to that order, my lord. 2011-2024.
Respondent number 5.
Respondent number 5 has filed, my lord. In that affidavit, my lord, we have said, my lord.
Now, if we are in a position to proceed, then we finish off this matter, 21 matter.
Yes, ma'am.
No point
But
adjourning
if
this.
they don't wish to file that affidavit, my lord, then
If he says it's not required to file, we'll go by the affidavit of respondent number 5.
Yes, madam.
Yes, what is the case
but
about?
then, my lord, we can take up on Friday, my lord.
Friday, today is Friday.
Next Friday. my lord.
We're not adjourning
Because
matters
on
of
the
21.
last 3-4 occasions, my lord, they have been taking time, my lord.
Only because of this tendency of this litigation, my lord, tender process has not been completed, my lord, and revenue has not been collected, my lord.
My lord,
And
the
the-
issue here, my lord, is, my lord, there is a pond, public pond, my lord, in the
How
land
Sri B.
record.
Kaushik, learned counsel for the petitioner. Para. Sri M. Chitia, learned state counsel has submitted that there may not be a requirement to file an affidavit through the circle officer, and the stand taken in the affidavit filed with respondent number 5 would cover the aspect. He has also expressed urgency as there is an interim order causing loss to public revenue. Para. Considering the above, list this case for admission hearing on 5th of February.
5th of February.
Yes, 5/2.
Well, oblige, sir. The interim may be continued.
Interim order passed earlier to continue till the next date of this.
Good.
Item 13, some mention was as many. A prayer for adjournment has been made on behalf of the petitioner. Para, list on 9th of February.
15.
Wait, please, Lord.
Mr. Laskar.
I'd like to file a short reply in this matter.
heard Sri M. H. Laskar, learned counsel for the petitioner, as well as Sri G. Bukolial, learned state counsel. Full stop. On the prayer of Sri Laskar, the matter is adjourned by 3 weeks to enable him to file rejoinder affidavit. List on 20 February. 20 তারিখ।
Obliged.
May it please, Your Lordship. When I
Yes.
have received the affidavit of opposition, I want to file the reply mail.
Ms. M. Burman, learned counsel for the petitioner, has submitted that. But affidavit in opposition was filed in 24
Yeah.
September 24, madam.
My lord, I have engaged Mr. M.K. Chaudhary. He said you file a reply first.
Mr. Chaudhary will not file the affidavit.
And I'll file my.
He'll file the affidavit. So, 1.5 years you could not file. How do you expect this court to grant you time?
No, 1 week at least.
At least. At most, how much?
10 days time, my lord.
Ms. P. Burman, learned counsel for the petitioner, has prayed for some time to file a rejoinder affidavit. Full stop. Also heard Sri G. Bukolia, learned state counsel, para. The affidavit in opposition was filed way back on 6/9/2024. Until now, no rejoinder affidavit has been filed. Full stop, para. However, as an exceptional circumstances, a further time of 10 days is granted to file rejoinder affidavit. Full stop. List on 13th of February.
May I please, Your Lordship, this is your non-payment of contractual bill amount. This is the second time litigation, my lord. On last occasion, 1/12/2020, this honorable court directed to file affidavit, lordship.
May it please his lordship. Lordship, I appear for BTC, my lord. Lordship, we have received an instruction, my lord, which says that since there is no availability of fund, my lord, that is why, my lord,
You have
the
to get
financial-
funds available. How you got him or her to do the work?
Lordship may kindly have a look on the instruction.
Now, when can you get the funds?
Lordship, for the financial year 2026-27, my lord, we have already written to the Secretary Finance Department, my lord. On 29 January 2023.
Done sometime, but this will not be an excuse.
Lordship,
Okay. Heard Miss A. Buzarbura, learned counsel for the petition, para. Ms. B. Bora.
Lordship.
B. Bora, learned counsel, learned standing counsel, BTC, has however submitted that the dues could not be cleared because of lack of funds, and in this regard, a recent communication has been made for allotment of funds by the state government.
To
For-
the Secretary Finance Department, BTC.
You have written to whom?
We have written, my lord, from the Additional Principal Secretary BTC to the Secretary Finance Department BTC.
No, don't state here, for allotment of funds. Para, in view of the aforesaid submission, matter is adjourned to be listed on 25th of February, on which date updated instructions are required to be given, to be obtained by the learned standing council.
I'm obliged.
May I please your lordship?
Yes.
Also, the petitioner, he is a management lessee in respect of a eco park, my lord. The government of Assam had taken a policy to develop certain tourist spots through private participation for development and management of those.
Madam Borua, you for whom?
I'm for respond number 2 to 5, Assam Tourism, Your Lordship.
You filed your affidavit.
Yes, Your Lordship, the pleadings are
Agents are
completed.
taken, lord.
If you are agreeable, we can have it for admission hearing on a date agreeable to you.
Yes, Your Lordship.
Heard Sri R. Sekhar, learned counsel for the petitioner. Also heard Ms. P. Barua, learned counsel, learned standing counsel, Tourism Department.
Lordship, I'm just a counsel, not a static.
Counsel, learned counsel appearing for the Tourism Department. Full stop. The pleadings have been exchanged and the matter can be taken up for admission hearing. Para? List, accordingly, list this matter for admission hearing on when? 26th February? Is it okay?
Lordship, yes, Your Lordship.
Yes.
Obliged.
26 too.
Much obliged. Lordship, may we submit the written submission for the hearing?
It's up to you, not required. If you want, you can.
Yes. Much obliged.
But this case, that Mr. Beagle is named to be recording corresponding number 6 to 8.
We can record your name. He's not the, Miss Sri M here. Has appeared on behalf of Sri B. Gogoi for the phone number 6 to 8. Who are 6 to 8? Finance department?
No, they on it's DC matter.
Okay. Okay.
Much obliged.
My lord, I am appearing in 20, item number 20, and they were asked to file an affidavit in clarifying the position. Because, my lord, they were giving a false information to the court, my lord, that I have pointed out. After filing my affidavit reply, they were asked to file affidavit, but they have not filed affidavit till today.
Lordship, today we have received some instructions, so.
What about the affidavit, madam? You are supposed to file.
Because Lordship, as per instructions, it's not permissible there.
What are these, madam? We don't really understand. What are the matters about?
Matter regarding, my lord, we are
Non-payment of.
non-payment of contractor bills, my lord.
Okay.
We file in, they have given a completion certificate. We have, in the time of crisis, my lord, we have done it. Everything has been completed. They have made an inquiry report also submitted, my lord. And then, my lord,
What about the liability aspect?
liability aspect, my lord, they are asked for the authority to clear the bills, my lord. Clear the bills, my lord. Now, my lord, they file a reply. The work, they have completed the work, that is true. But the work which have done, that is not permissible under this scheme. That is their affidavit. So then I file a reply. It is mentioned in the scheme, my lord. I pointed out before this honorable court that it is under the scheme I have pointed out. Then this honorable court asked them to clarify that stand, my lord.
Are those works under the scheme, madam?
Lordship, as per instructions, the.
As per
schemes are
instruction,
not-
they have already filed affidavit earlier.
Yes, Mr. Mohta, what is the Supreme Court decision which the full bench did not, in Tamsir Ali has not followed regarding payment of contractual bills?
Sincerely, my lord,
Tamsir Ali, you said that there is some Supreme Court decision?
there is a Supreme Court decision, my lord. No, not Samsher my lord. I am not talking about Samsher.
No, Tamsir Ali.
No, Samsher is contractor bill, that is different.
No, you have said that there is some Supreme Court decision.
There is a Supreme Court
Please
decision,
place it before us.
that is, my lord, 2000.
Because we are following Tamsir Ali, full bench. We are bound by a full bench. If there is any Supreme Court decision,
There is a Supreme Court decision, there is a long back 2004.
Let us see.
That is in disparate context, my lord. That is a context in all disputed matter that cannot there. It is not the digit law that all the disputed matter you cannot entertain.
so Tamsir Ali still stands. How can you say
Something
that?
still stand, my lord. I am
How
not
can you
talking-
say that Tamsir Ali will not be applicable?
No, I am not talking about Samsher Ali.
No, we have got the information that
No,
Tamsir Ali is
I-
not applicable.
I say that 2004 judgment, that Samsher Ali is later that.
See, Tamsir Ali has not said Writ Court will not be in a position. Tamsir Ali has only given certain principles. You cannot flood this Writ Court to a recovery
No,
proceeding.
2004, my lord, probably somebody misquoted my submission, my lord, maybe. I am not on that. 2004 date judgment, your lordship kindly see 2004 3 SCC 553.
What does it say?
That says, my lord, even as some disputed question, it is not that the court cannot interfere. It is
It's
all
not a
matter-
question of disputed questions. It is a question of admission by whom. If
No,
the full
that-
court has said that the admission has to be by the head of the department or the chief engineer, can a single judge say that no, the executive engineer will suffice?
No, that
Where is
that
where is the judicial discipline?
No, that is not.
Where is the
decision-
decorum?
That is not the decision
Aren't
here.
we not
No,
required
that
to
is
follow
not
the
the
full
decision
bench?
Here, my lord. That is not the decision here, my lord. Probably, my lord, what I said that is wrongly quoted before your lordship.
But
I am stated that, my lord, there is a 2004 judge, when all the disputed question cannot be thrown out right way. That is the, my lord, my submission.
Writ court is not a question, is not a court
No,
on
that
facts.
judgment, my lord, that is 2000, my lord. I
They
am
are not a court on facts. If dispute arises, your approach to the civil court is open.
No, that is not. That, in that case, my lord, that 2004, my lord, 3 SCC will prevail.
Let us see what is 2004 3 SSC.
My lord.
So, What is the name?
But that is not the issue here, my lord.
What is the
The
name?
name, my lord, ABL International and others.
ABL Lemonade.
Yes, my lord.
Lemonade is in a different context.
No, that your lordship kindly see.
That is money decree kind of can be passed by read
No,
code.
here, my lord.
That
the
is not
finding
the
is that-
dispute at all.
No,
That is
here-
not the dispute at all. Let me
No,
ABL
here finding is
Lemonade
no,
on a
what I
different.
am submitting, that all the disputed question that cannot be entertained, that is not the rigid law. If there is even a disputed question, some my lord, court can entertain 226, my lord.
Let us
That is
see.
the law, my lord, your lordship kindly. Merely because some disputed question of fact arise for the consideration, some cannot be a ground for refusal if any entered in edit petition in all cases and matter of matter is rule. It's a matter of rule, it cannot be, my lord. That is my submission. Probably, my lord, I'm sorry to say that. my lord.
It can be it can be a matter of prudence. That yes, in an exceptional
So that is-
circumstance.
that is,
But
here,
for passing an order for release of contractual dues
my lord,
in absence of the requirement which has been laid down by the honorable full bench,
my lord.
can we say anything else? Are we in a position to say?
No, I cannot.
That is where we're trying
But
to.
that is, I am saying that 2004 rule, my lord, judgment is there, my lord. The Supreme Court says that merely because, my lord, disputed
No,
question.
we are not
cannot-
on the disputed questions of fact. We are on the requirement of an admission by which authority? There can be an admission of liability.
Then, my lord, all right, that Pullman's judgment is there, my
If
lord.
the honorable full bench has said chief engineer, we cannot substitute and say, no, even a superintendent will do. Can we do so?
No, my lord, fact the case will be, my lord, depend upon the, that law will be applicable to facts of the case, my lord. No, here your lordship kindly
No, it's
see.
not a
if-
question of
if you-
that. If there is a liability, if there is a prescription by the full bench that a liability has to be the head of the department or by the chief engineer, can we substitute that as a single judge? Question is that.
No,
It's
that
not-
cannot be, my lord. But that was not the question here, my lord.
Yes, madam.
No, here we are.
Well, how do you clarify this point?
Lordship, this point not clear, I'm not clarified, and department has
No,
not.
what he's saying, that you took a stand that it is not a part of the scheme.
Lordship.
Now, in the rejoinder affidavit, he has pointed out that the scheme itself has got certain aspects which the work he has done would be covered. Now, it appears that the earlier stand was not a correct stand.
So that's why they were asked to
That,
clarify.
yes, how do you clarify this?
Lordship, as per instructions, kindly say, the considering the above you are.
Which letter? Which one?
Lordship, at 31/2026.
Yes, what is it?
Considering the above, we were requested to take necessary action to recover the amount from the hearing officials responsible for take non-permissible work according technical section, administrative section, and execution of mentioned works under Basing Darwa Development Block, Dhubri, as per the letter dated 20/10/2020 issued by Government of India, Ministry of Rural Development Department, Department of Rural Development, New Delhi. Then Lordship, this annex.
You were supposed to give an action taken report also.
Yes.
This was on 31/2026, recent
Lord-
days.
Lordship. So.
But that position which Mr. Mahanta is raising, that is even not clear. Now you are saying that you are to take necessary action
Then-
for recovery from the officers who are responsible for non-permissible work.
Because.
Mr. Mahanta is trying to say that it is a part of the scheme, so it's
Yes,
a permissible work.
permissible work.
But Lordship, as per and annexer one, annexer annex one letter to, we have already from MG Enrega. We have already received the letter from the Ministry of Rural Development Department, New Delhi. Then this annexer kindly see para 3. The matter has been examined by the ministry. According, it has been decided to issue an advisory, and in case of any such non-permissible activity has already been done under any head of the permissible work under Mahatma Gandhi and NG Enrega, state should ensure that due recovery of the expenditure already incurred from the concerned officials, agencies.
Which is your matter, Mr. Mahanta? Uttam Saha.
Uttam sir. Item number
In your case, affidavit has been filed.
My affidavit-
Others not filed. But it will cover.
But that part not receive any written instructions from the department.
But this letter of 31, today's
No.
letter,
Yes.
still gives the impression that you are considering the work done by the petitioner to be outside the scheme.
Not. So for that.
And on this aspect only, you were directed to file the affidavit, which you have not done.
Today we have received instructions, so I am filing this affidavit.
You filed the affidavit,
Lordship.
but we'll clarify that one affidavit will cover, because in the last case, last date, we had stated that your colleague had prayed for time to file affidavit in opposition, which was already, okay, heard. Three. Mr. Khondokar, you appear for the other cases?
Yes.
Heard Sri T.J. Mahanta, Learned Senior Counsel, assisted by Sri M.R. Khandakar. For the petitioners, full stop. This also heard Miss N. Bora, Learned Standing Counsel, PNRD, who has informed that insofar as WPC 4736 of 2024 is concerned, the department has filed the affidavit in opposition, which would cover the other cases also. Full stop. Sri Mahanta, the Senior Counsel, has submitted that that rejoinder affidavit has been filed on 29/8/2025. Full stop. He has also submitted that the department is required to clarify as to whether the work done by the petitioner is to clarify their position with regard to the works vis-a-vis the scheme in question, for which time was earlier vis-a-vis the work in question. Ms. Bora, the Learned Standing Counsel, has placed before this court written instructions and has prayed for some time to put the same in the to file a further affidavit. Full stop. Para. When can you file? Mr. Mahanta, please suggest a date.
My lord,
Can we have it on 19th? Before 9th?
Lordship.
Before that, you have to file it.
my
19th.
lord, my lord.
List on 19 to 2025, by which date? 2026, by which date? The additional affidavit is required to be filed. Mr. Dutta, you are for whom? CGC. Sri A.K. Dutta, Learned CGC is present. How is CGC connected? Central scheme.
Central scheme. On labor payment they have made, my lord. I supplied that labor payment they have made. Rest, my lord, they have.
Okay.
Regarding Samshed, again I'm submitting. I am not on that.
Tamshed, not
Samshed. I am
Tamshed.
not on that. I am not.
Not
That is
Samshed.
still like this, my lord.
You must have read Samshed. You have to read Tamshed.
My lord. But that judgment, my lord, regarding my lord, outway state way rejected for my lord, because this is a disputed question, it cannot be rejected on that ground alone.
We are not rejecting on that. We are rejecting
No, no,
only on the
I am on
requirement.
that point only.
On the rejecting on the lack of an acknowledgement by the chief engineer or the head of the department.
But in
Not
certain,
on disputed questions.
but in all cases, my lord, the chief engineer cannot be involved, my lord. In some cases,
That is why head of the department.
my lord, head of the department.
It's clarified, and if there are no such, you have to go to the full bench and get a clarification.
My lord.
We cannot find an error in a full bench.
But here in this case, my lord, some different point. my lord. Lordship kindly on the, because they have made an inquiry also. Inquiry also, my
Okay,
lord.
next.
Different.
Twenty?
Wait, please, your lord. My lord, the petitioner participated in the tender process.
Mr. Datta and Kotoki on the same side.
My lord, two different respondents.
You share a table in the bar. Inseparable friends. We'll ensure that one day somebody of you has to come to this side. We're waiting for that litigation. Yes, what is it?
My lord, the petitioner participated in the tender process
Yes.
pursuant to the NIT dated 22/7/2024 floated by respondent number 6 and 7.
For NIT for?
NIT for operation and maintenance of 2 parks in Silchar town. Now, the criteria was that there should be bidding to the extent of percentage of revenue to be shared with the municipal board authority, the municipal. Now, the petitioner bidded 57% of the revenue to be shared with respondent number 6, thereby became the highest bidder. Now,
You would give 57% to the,
yes, the revenue to be shared with the municipality after the accruing of the profit out of the maintenance of the park. Now,
you offered 57%.
yes, and
You emerged as the highest bidder.
I was given to understand, my lord.
Okay.
Respondent number 8 offered 37%. The bids were opened on 31/7/2024. 31st July 2024.
Yes.
Now, on 31st July 2024, after the bid positions were conveyed to the respective participants, I was informed verbally that I have emerged the highest bidder. And eventually,
Just a minute. কথা কব মনা কৰিছা ন কথা কব মনা কৰা বাহিৰ কথা বলি Yes.
eventually on 16/8, in fact, before that, my lord, there are 2 communications.
What is your difficulty?
Now, difficulty here now is, after having been directed to appear before the tender evaluation committee subsequent to the opening of the tenders and emerging as,
Both you and the respondent number 8.
no, only the petitioner.
You are directed to appear
I
before.
was directed to appear before the tender evaluation committee, and I was also directed to submit the tentative plan for operation and maintenance of the 2 parks, which I submitted.
Yes, yes.
Now, thereafter, the work order did not come. The work order was not coming, and eventually I got to see that the operation and maintenance of these parks were being carried out by respondent number 8. I inquired it from the municipal board authorities. Municipal board authorities eventually conveyed that because of my lack of experience and because of non-furnishing of certain things which were required according to the municipal board in terms of the NIT. Now, respondent number 8 has been conferred with the work order, and insofar as his shortcoming or shortfall regarding the bidding of 37% compared to 57% by the petitioner, that has been allowed to be increased in the same tender process after the opening of the tender on 31/7/2024. Thereafter, the respondent number 8 has been given the opportunity to increase his bid of 37% to 57%.
Your bid.
To be at par with my bid, and he has been conferred the work order on 25/9/2024. Now, 25/9/2024 is something that I was not aware of, my lord, so that is not under challenge in the petition. That is something that I have only come to know after the filing of the affidavit in opposition by the municipal board, and I have responded to that also. So my grievance here is that on a projection that I am selected, in fact, after being conveyed, it is apparent that my bid was 57%, being the highest one. Now, thereafter, in the affidavit also, it is an admitted position of fact that during the after the opening of the bid, a second highest bidder gets the opportunity to raise his bid and become at par with me, and then get
The work.
the work. So this is my case.
Yes, Mr. You are the decision-making authority.
My lord, I'll take your lordships to my affidavit at page.
If you negotiate with Mr. Kotoki, why don't you negotiate with him?
No, your lordship, kindly see what happened. Now,
How do you give the second highest bidder the work at the bid of the, without even negotiating. Perhaps you would have given more.
No, I have a strong reason for that. Look,
Okay.
if I take your lordship
What is it?
to, your lordship kindly see whether he has complied with the terms. Your
Okay.
lordship may kindly come at page 56,
56.
57 rather.
Yes.
Then, my lord, serial number 5, certificate in respect of satisfactory completion of similar nature of works under government or semi-government department during last 2 years along with work order. Tender must have been completed. Now, this is one part. Then your lordship turn to the next page at page 58.
58.
60, my lord.
60.
This is 60, the clause 27. The contractor shall, the lordship got that.
Yes, please.
That the contractor shall provide in the joint names of the first party and the contractor insurance cover from the start date to 28 days beyond end of the operation and management liabilities in the amount and deduction stated in the contract data for the following events which are due to the contractor's list of amusement items mentioned in Annexure A. Now, your lordship will not find in the writ petition this Annexure A. That has been withheld. That the reason that your lordship should not know that. Now, we have annexed that at page 63. Uh, 63.
63.
63. 2 to 3, 50. Provision rules. Now, these are the items, my lord, in the Gandhi Park, Gandhi Bagh Park and Narsim Kala Park. Now, this person who has been given 57% revenue. Now, your lordship kindly see his status. My lord, at page 64, your lordship will first see that his experience for 6 months only.
60?
64.
It's a part of your affidavit.
Yes,
Oh.
it is part of my affidavit. This to the contractor, we have the chairman municipal board Hailakandi. He said that he has the experience in Hailakandi municipal board.
Just
And he annexed a letter.
64 to- Yes, yes, Annexure B.
Annexure B.
What,
yes.
your name is Piyush Kanti, Mr.
Piyush.
Chakraborty?
With reference to the subject matter cited above, you are hereby informed that your tender has been accepted by the undersigned for leasing out of so and so for the period 1/10/2023 to 31/3/2024 with regular maintenance of the said park. It's just for 6 months.
By Hailakandi Municipal Board.
Yes,
Now, how much experience do you require?
that's a experience, my lord, is a project for 5 years.
Let us see again.
Similar words that your lordship will find in clause page 57, page
Yes.
5.
57
Certificate-
experience clause at page 57, serial number 5. Let us see what is serial number 5.
Certificate in respect of satisfactory completion of similar nature of works under government or semi-government during last 2 years along with work order. Tender must have completed same nature of work at least one number in single work order in the
There is
last.
no time period as such.
But then your lordship,
2 financial years.
2 financial year.
No,
Single work of 2
he
financial.
must have completed same nature of work, at least one number in single work in the last
Two
2 financial years. Yes. Within the last 2 financial years, he has to do a similar nature of work.
Similar nature of
There is no duration.
But then if the project is for 5 years, he is giving experience certificate.
No, you
of
are
6
adding
months.
words to your clause, which can you do so?
Now, apart from that, some other also things are there. Now, your lordship kindly see the next letter, that is also certificate given by the municipal board, Hailakandi,
Page?
page 65. For 6 months.
65. 65, 65. okay.
65, yes. Is to whom it may concern. This is certificate given by the municipal board, Hailakandi.
24.
Then, my lord, our executive officer, he wrote to the executive officer Hailakandi, my lord, saying that in the context at page 66, my lord. In context to the subject referred above, the undersigned would like to apprise you that the aforesaid letters have been submitted by the lessee in connection to the tender invited by this office. As such, you are hereby requested to furnish the details of the quantum of lease area along with the list of equipments installed therein, and also to validate the letters referred above, preferably within 3 days from receipt of the letter for finalization of tender from our end. Now, they have clarified it. In the next page, page 67.
But these are two different forms of work.
No, the what the experience and what sort of, my lord, the work he did.
Just a minute. Accepted and does not really count through material. Oh, 64 and 65 is the same.
Same.
65 is the completion certificate.
Completion certificate.
It is not for a different period. It's the same
Yes,
period.
same period for 6 months. only. That is what I'm-
64 is the allotment of the work and 65 is the satisfactory report on completion of the work.
Yes.
If you see the period 1/10/23 to 31/3/24, same
Right.
period.
Now, we wanted to verify those
Okay.
document, my lord, that
Okay.
your lordship has seen at page 66. Then the.
66.
66, yes.
Okay, verification process.
Then, my lord, page 67, municipal board Hailakandi informed us, your lordship will find details are as follows. Quantum of lease area is 1,500 square meter, whereas the Gandhibar Park and the Narsingtola consist of 6,400 square meter. Equipment installed, LED lights with pole, visitor sitting arrangement, etc.
Yes.
Now it has got no match with clause 27. And as your lordship has seen in annexure, this page 63, my lord. Your lordship kindly see once again, annexure 1.
Page 60?
63. Your lordship will find in Gandhibar Park and Narsingtola Park, what instruments are required. And what experience he is having. He is having some LED light with pole and visitor sitting arrangements. Now, does it match with the clause 27?
With the letter on the reference for manual necessary details are.
No, matching of the work, if your lordship see, substantially different. Here, my lord, he is having some, my lord, LED light and some chairs for sitting arrangement. Now, the experience is substantially different, my lord. These work can be done by Mr. Piyush Kumar Majumdar, anybody in some small places. Now, this experience is not matching with the Gandhi Park because it's a huge place having 6,400 square meter, having so much of instruments. Now, how this person can effectively do all these works? Ultimately, my lord, the public interest will suffer. So keeping back in mind all these, my lord, we have now your lordship, if I can take your lordship to page 68. How it is evaluated. Page 68, I will just read the last few lines.
Yes, yes. Yes, please.
After threadbare discussion, the committee adopted the following resolutions. After thorough examination of credential papers submitted by so and so, the committee decided to verify the papers from the issuing authority for its genuineness, and also to know the land area and equipments installed in the said garden park,
Yes.
and the committee will take the decision on the matter after obtaining the authenticated report from the Hailakandi Municipal Board, as your lordship has said.
Yes.
Then, my lord.
You took a decision to get it verified.
Yes, and we have verified.
Hmm.
And then, my lord.
But this was with regard to the credentials submitted by Pushpanjali.
Yes, Pushpanjali.
You are
means
Pushpanjali, or
Vijay
you are
Kanti,
Pushpanjali?
Yes. Then at minutes of the meeting at page 69, your lordship will find minutes of the meeting of the tender evaluation committee held on so and so in the office of chamber of the executive officer Silchar Municipal Board. At the very outset, DDC come chairman of the committee. Page 69. my lord.
69 is the same, I think.
No, it's not the same. It's a different one.
Okay, okay. This is what date? 1908. 1908.
1908.
19, you are correct. 1908.
Page 69. The first and foremost, the executive officer Silchar Municipal Board apprised the House regarding the decision adopted in the meeting held on so and so. As regards to that, the authentication letter dated so and so issued by the Hailakandi Municipal Board has placed before the House. The executive officer of Hailakandi Municipal Board has verified and authenticated.
Okay, okay. We
the
have
letter.
read, we have read.
And then, my lord, as your lordship has seen the LED light and some.
Yes, we have read this.
Then, after threadbare discussion, the committee adopted the following resolution. After thorough examination and analyzing the last 1 year collection and expenditure of both the parks, it appeared that the average monthly collection of Gandhi Park of last preceding year is approximately 3 to 3.5 lakhs per month. And the average expenditure of both the parks of last 1 year is approximately 2 lakhs per month. However, Mr. Pushpanjali Varieties has submitted his tentative expenditure of both the parks amounting rupees 1,67,000 only per month, which seems to be unjustified, which may affect or negotiate the quality and maintenance of both the parks from his part of 43% share, and thus committee unanimously decided to call and meet in person Sri Piyush Kanti Chaudhary, proprietor of Messrs. Pushpanjali Varieties, to clarify and justify the findings and doubts of the committee. The meeting ended. Over. Then your lordship kindly see at page 70, the minutes of meeting dated 30/8/2024. Okay.
70.
70.
Yes.
At the very outset, DDC Kachhad, chairman of the committee, welcome all the members. The executive officer assembly apprised the House regarding decision adopted in the meeting held on 19/8/2024 as regards to that. Both the periods appeared before the committee one by one. Thereafter, the committee once again analyzes the tentative expenditure submitted by Piyush Kanti Chaudhary, proprietor of Pushpanjali Varieties, and put forwarded their findings and queries about the expenditure statement and future planning of development of both the parks before Sri Piyush Kanti Chaudhary. Sri Piyush Kanti Chaudhary expressed his views against the queries by his submission before the House. He stated that the tentative expenditure which is submitted by himself is not fixed, and expenditure can be reduced by engaging his family members who can be served voluntarily for him. Your lordship can see the wordings. He also stated that he has no such experience of running amusement park. Now he doesn't have the experience, he is admitting that. Further, the second highest bidder, Sri Diganta Mandal, proprietor Istan, also asked by the House to enlighten the previous experience of running both the parks and future planning of development of both the parks, and also offered the H1 rate, that is 57% share, to the assembly. Sri Diganta Mandal, proprietor so-and-so, expressed his views against the queries by submission before the House, stated that he had developed, upgraded both the parks under Amrut project, and he has vast experience as well as expertise of equipments installed in the parks, and he has well maintained both the parks for last 23 months. He also quoted that in each and every occasion, he makes both the park aesthetically appealing for increasing public gathering, but that he also agreed the offered rate put forwarded by committee and ready to revise his bid up to 57% instead of 35% share to SMB, Shilcher. However, he urged if the house allows him to contribute 50% share to SMB, then he can use the surplus amount for the betterment as well as development of both the parks. After threadbare discussion, the committee adopted the following resolutions. Just a minute. After thorough examination and analysis the past 23 months of collection and expenditure of both the parks, it appears that the average monthly collection of Gandhibar Park is approximately rupees 3,35,000 per month, and the average fixed expenditure of both the parks is rupees 1,93,000 per month. However, Mr. Pushpanjali Varieties has submitted his tentative expenditure of rupees 1,67,000 per month, which seems to be unjustified. The submission of Sri Piyush Kanti Chaudhary before the House is found quite unethical and fundamental, also found not feasible by the House. Moreover, the salaries quoted against the laborers operators are much below the minimum wages as per the government notification, which might result in employment of substandard and non-personnel, thereby jeoparding the assets of the park in the long run. The House expressed their satisfaction towards the past performance of Sri Diganta Mandal regarding O&M of both the parks. The House asked him to submit a tentative plan of the development of the parks in near future, tentative expenditure statement of both the parks, considering the previous expenditure of both the parks. The committee comes to in a decision that the development was maybe managed by his part of share 43%, and thus the committee decided to put forward the resolution of the meeting to the DC Kachar for consideration his request and accepted his revised H1 rate 57%. Then the work order was passed on 25/9/2021, that is at page 72.
70? 72.
Page 72. 24. Yes.
This work is for how many years?
5 years.
5 years.
Six, 27.
Yes, what is the scope of judicial review?
My lord, yes. Now, my lord, I will take your lordship fee decision of the appeals court. My lord, I will
Contractual matters?
Yes. All the decision I'll give. to
Which
your
one?
lordship.
CCL?
My lord,
Jagadish
first-
Mandal?
My lord, first, my lord, I will take your lordship to 2016, 16 SCC 818. Afcons, my lord.
AFCON?
Yes. Extra copy, yes, no?
Please give the citation of AFCONs.
To the, my lord, I am having extra copy, I'll give it to you. lord.
Give the citation, we can. write it.
2016, 16 SCC 818.
AFCON, I think, has also quoted expected from Jagadish Mandal.
It is referred.
As well as Milord.
CCL?
Silpi construction.
Huh? Silpi?
Shilpi Construction. Then my lord, Agmetal India. I'll refer only para 11, 12 and 13.
CCL has been referred. Then. CCL has been referred in.
Referred.
And Jagadish Mandal.
Is referred.
Shilpi is different. Shilpi is also might also help you. But Shilpi was only on SCC online. It was not reported anywhere else. To the best of our knowledge. Shilpi was only in SCC online.
Yes, my lord.
Not in.
Which one, my lord?
Shilpi construction.
Shilpi, it is there,
It
to
is the Supreme Court.
2020.
20 it has come.
SSC.
Please give the citation.
Yes.
2020, 16 SCC,
2020, 16 SCC.
489. Relevant paragraph is paragraph 19 and 20.
And FCON paragraph?
Abscon is,
Paragraph 11, 12, 13.
yes, 11, 12, 13. 11, 12, 13 and 14.
Just a minute, please.
Give me one. Paragraph 27 to 4, I think. You know, then Agmetal, my lord, this is a better judgment, 2022 5 SCC. Page 362.
Metal is what?
Paragraph, with 2022 5 SCC, page 362.
2022 5 SCC.
Page 362.
362.
Paragraph 25 and 26. It is extra accessible. It is the white metal. I would like to read my lord Agmetal first. Page 25 at page 380.
Page?
Page 380, paragraph 25.
Yes.
This court referred to various decisions on the subject and stated the legal principles as follows. In a series of judgments, this court has held the authority that authors the tender documents is the best person to understand and appreciate its requirement, and thus its interpretation should not be second-guessed by a court in judicial review proceedings. In Afghans Infrastructure Limited, Nagpur Metro Rail, this court held we may add that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate its requirement and interprets its documents. The constitutional courts must defer to this understanding and appreciation of the ordered tender documents unless there is a malafide. These are the, my lord, the area where your lordship will enter. Unless there is a malafide or perversity in the understanding or appreciation or in the application of the terms of tender of conditions. It is possible that the owner or employer of a project may give an interpretation to the tender documents.
Mr. Chakraborty, have you seen?
That is not acceptable to the constitutional courts, but that by itself is not a reason for interfering with the interpretation given. In the judgment Bharat Coking versus so and so, lastly, we deem it necessary to deal with another fundamental problem. It is obvious that respondent number 1-6 to only enforce terms of NIT. Inherent in such exercise is interpretation of contractual terms. However, it must be noted that judicial interpretation of contracts in the sphere of commerce stands on a distinct footing than while interpreting status. The present facts, it is clear that so and so, now your lordship may skip these. Then, the next page, the High Court ought to have deferred to the understanding unless it was patently perverse or malafide. Given how BCCL's interpretation of these clauses was plausible and not absurd, only differences in opinion of contractual interpretation ought not to have been grounds for the High Court to come to finding that the appellant committed illegality. Then the next regarding Shilpi construction. The essence of the law laid down in the judgments referred to above is the exercise of restraint and caution. The need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities, the court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of its requirement, and therefore the court's interference should be minimal. The authority which floats the contract or tender and has authored the tender documents is the best judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The courts will only interfere to prevent arbitrariness, irrationality, bias, malafide, or perversity. With this approach in mind, we shall deal with the present case. Then, my lord, your lordship may see next page. There are 22 of Shilpi, of Jagdish Mandal.
No, this Jagdish Mandal is quoted.
That your lordship is aware. Should I read, my lord, this paragraph?
Not required.
My lord, then, my lord, we can go back to paragraph 26, my lord, at page 384. The above mentioned statement.
Jagdish Mandal is in prior point of time or Michigan rather. Michigan, I think.
I think prior.
Because these are all, I think, same paragraph is also in Michigan.
Yes, Michigan is also.
I think Michigan is a prior.
Prior to.
I think
prior
this,
to
this
Jagdish.
is an extract of Michigan, I think. No, this same paragraph is only same paragraph. I think Jagdish has simply extracted. I do not know which was of prior point of time. Michigan is later, I think. Michigan.
The relation to salary.
Well,
Rohiri to Kiman? Prior. Well, Jagdish Mandal, I am told, is a prior to Michigan.
Okay. Then probably Michigan has extracted Jagdish Mandal again.
Yes.
22, paragraph 22.
Then, my lord, if your lordship can see the paragraph 26 also, the same thing. The above mentioned statements of law make it amply clear that the author of the tender document is taken to be the best person to understand and appreciate its requirement, and if its interpretation is manifestly in consonance with the language of the tender documents or subserving the purchase of the tender, the court would prefer to keep restraint. Further to that, the technical evaluation or comparison by the court is impermissible, and even if the interpretation given to the tender document with the person inviting offers is not as such acceptable to the constitutional court, that by itself would not be a reason for interfering with the interpretation given. So therefore, under such a scenario, my lord, the courts will keep a miles away, my lord, to enter into all that. My lord, then, my lord, your lordship may see 2016, paragraph 11, 12, and 14.
AFCON.
My lord.
AFCON you have already placed, I think.
Yes, yes. I did not read it, but.
Paragraph?
Paragraph 11, 12, and 12, 13, and 14.
Paragraph 11.
11 to 14.
Yes.
Paragraph 11, my lord, it was held by this court, relying on a host of decisions that the decision-making process of the employer or owner of the project in accepting or rejecting the bid of a tender should not be interfered with. Interference is permissible only if the decision-making process is malafide. The law is all the same, my lord, or is intended to favor someone. Similar, the decision should not be interfered with unless the decision is so arbitrary or irrational that the court could say that the decision is one which no responsible authority acting reasonably and in accordance with law would have reached. In other words, the decision-making process or the decision should be perverse and not merely faulty or incorrect or erroneous. No such extreme case was made out. Now 12, so and so it was held that the constitutional courts are concerned with the decision-making process. Tata Silver versus so and so went a step further and held that a decision, if challenged, the decision having been arrived at through a valid process, the constitutional courts can interfere if the decision is perverse. However, the constitutional courts are expected to exercise restraint in interfering with the administrative decision and ought not to substitute its view for that if of the administrative authority. This was confirmed in Jagdish Mandal versus so and so. In other words, a mere disagreement with the decision-making process or the decision of the administrative authority in no reason for a constitutional court to interfere. The threshold of malafide intention to favor someone or arbitrariness, irrationality, or perversity must be met before the constitutional court interferes with the decision-making process of the decision. We must reiterate the words of caution that this court has stated right from the time when Ramanna Dayaram Shetty versus International Airport was decided almost 40 years ago, namely that the words used in the tender documents cannot be ignored or treated as redundant or superfluous. They must be given meaning and their necessary significance. In this context, the word so and so, so and so. Now, the last decision, my lord, Ronak International 99 1 SCC 498.
But Mr. Kotoke is running the show. Why are you showing Ronak? Is there any interim order?
No interim. He is running.
He's running the show.
And is running very effectively. No, please don't. Hello, can I take your lordships to a decision of the appeals court reported in 1999 1 SCC?
Name?
Ronak International.
Ronak is only for the purpose of not to grant any interim order. If you do it,
I'm
it is
not
it is
on
on the
that.
peril of the petitioner.
Yeah, I will just read para 27.
What is it?
My lord, some factual background is there. Copy it.
Tell us the principle, we'll
Yes,
remember. We'll
in the
remember.
present case, however, the relaxation was permissible. Under the terms of the tender, the relaxation which the board has granted to Messrs. Ronak International is on valid principles looking at the expertise that tenderer and his past experience, although it does not exactly tally with the prescribed criteria. What is more relevant, Messrs. Xavier Construction Limited, who have challenged this award of tender, themselves do not fulfill the requisite criteria. They do not possess the prescribed experience qualification. Therefore, any judicial relief at the instance of a party. Therefore, any judicial relief at the instance of a party which does not fulfill the requisite criteria seems to be misplaced. Even if the criteria can be relaxed, both the Ronak International Limited and so, it is clear that the offer of Messrs. Ronak International Limited is lower, and it is on these grounds that the board has accepted the offer of Messrs. Ronak International. We fail to see how the award of tender can be stayed at the instance of a party which does not fulfill the requisite criteria itself and whose offer is higher than the offer which has been accepted. It is also obvious that by stopping the performance of the contract so awarded, there is a major detriment to the public because the construction of two thermal power. Now, these are the different things. Now, here exactly, my lord, the so far factual background of the case is concerned. My lord, it is similar to this case itself. So therefore.
Why, how is it similar?
My lord, here what happened, my lord? He has quoted 57% share will give to the municipal board.
Yes.
And Mr. Kotaki's client has given 37%.
Correct.
Now, ultimately, we found that he doesn't have the, my lord, so far the requirements are concerned, he did not comply at all. My lord, it is such a huge area, 6,400, and he was maintaining 1,500 square feet. And the instrument, what he has handled, some LED light. And
now, where is the impugned order here? Was there any order passed regarding rejection of his bid? So far as the allotment of the work to Mr. Kotoke is concerned, that they have brought on record.
The work order you will find that we have.
Work order we have seen, 24th. That has come subsequently. But what about the aspect of consideration and communicating to him?
Yes, that I will just. The House, page 71, Milon. The House expressed their satisfaction toward the past experience performance of.
No, that minutes you have placed on record. this is the consideration,
Yes.
part of consideration of his bid
Right,
and the decision to go ahead with Mr. Kotoke, not to him.
yes. That we have considered as,
Is there a requirement to communicate the rejection?
rejection, my lord, he was there, he was consulted, he was informed. And by these, my lord, is meticulously served the purpose of all these. And he was in know of all this thing. And regarding expertism, my lord, he has admitted himself.
So these are not grounds which you have put only in the affidavit, these also exist in the minutes.
Yes.
So you are not covered by Gordhan Das.
No, no, not at all.
It's not trying to improve your case in the affidavit.
No, no, it's not that. It's not-
Minutes contains the reason.
Everything it contains. Govardhan Das in different factual aspect.
No, you
We-
cannot
we-
improve.
No, we are not trying to improve. It
That-
is
that
already
is it.
there.
That is what we are asking. The
Yes.
minutes itself
Minutes is
contains the reason. It's not that in the affidavit you're trying to supplement the reason.
exactly all these things are clarified here. So therefore, since Mr. Kotoke is doing well there, I don't think there should be any disturbance at this stage. And merely, my lord, only fact your lordship kindly see, he has withheld a document from your lordships, Annexure A. He ought to have produced before the court, because with the idea that when I move it, I can get an interim order. But if I give it, the honorable court will see, and seeing that they will keep their mind okay that, well, it's not that kind of case where he is trying to project. Now, this is.
Are you
also
trying to, I am trying to project that the requirement of experience has to be commensurate with the nature of the work so far as
Yes,
which
yes.
is to be allotted.
Exactly, my lord.
The experience which Mr. Chakraborty has is with regard to maintaining a park of a smaller magnitude
Very
and
good.
only for installation of LED lights with poles.
Right.
Here you have many other aspects of maintaining, not only maintaining installation of swings,
Yes, yes.
children park and amusement.
Yes. And this Annexure A clarifies everything, and which he has withheld from the court. That hide and seek thing, my lord, we should not do it before the court. So whatever case I am having, I must project it correctly.
No, but he has given us experience certificate. You may have good reasons to say that this experience certificate may not be the one which you are looking for.
Yes.
Your experience has to be commensurate with the nature of the work which is sought to be allotted.
Very, very well. That is our case, my lord. Because after all, my lord, if I choose him, what will the eventuality will be the public sufferance.
Okay, we'll hear Mr. Kotoke at 2 o'clock. Mr. Chakraborty would like to give a rejoinder also. You give a common rejoinder after Mr. Kotoke.
Yes.
Mr. Day. Mr. Day, we wanted to, your the colleague on the other side wanted some time. Mr. Day. He wanted some time to have the instructions.
They are seeking time.
Yes, they wanted to have, we'll grant some time, but we wanted to greet crime in your presence. So we'll give a.
Short date, may time.
No, he wants time to get instructions. The parliament session is on. So he has paid for a month's time. We may not grant a month's time. We'll have a date sometime on 19th of February. Is it okay?
My lord, sir. My lord,
19th. Mr. Kumar, you are online? Yes.
Yes, my lord, item 51, my lord.
Yes, 19th February.
My lord, can it be up in the last week? Anyway, 24th, 25th February, my
Okay,
lord.
then 26th of February.
I'll be grateful, my lord.
Heard Sri A. Kumar, learned counsel who has appeared online. Also heard Sri L.C. Day, learned counsel for the workmen. Para. The matter was fixed today to enable Sri Kumar, the learned counsel for the petitioner, to obtain instructions. Full stop. The learned counsel is, however, informed that because of the ongoing parliament session, the instructions could not be obtained, and he prays for some time. Para, considering the facts and circumstances, the matter is adjourned to be listed on 26 to 2026.
I'm so deeply obliged, my lord.
Item number
Deeply
29, my
obliged.
lord. Maybe on Tuesday, my lord. I have some personal difficulty. Or
Okay, I have somebody here will fix
Yes,
it.
I'm for the petition of that, maybe can be fixed on Tuesday.
Fixed on, item number
29.
29. Sri J. Roy, learned counsel for the response number. Third senior counsel for response number.
Sole respondent.
Sole respondent has prayed for an accommodation. Also heard Sri Muzumdar, learned counsel for the petitioner. Para, as agreed to by the learned counsel. List on
3rd, my lord.
3rd of
February, my lord.
3rd February. Okay.
Another item, my lord, I have actually not difficulty, but the driver has got some difficulty in the second hour, he wants to go.
Let the driver go. Driver will not do the case here. If you don't have a difficulty, you be. Mr. Pathak will arrange for your conveyance.
Very good.
Okay,
Okay, when do you want?
I'll do it, my lord.
When?
Do it.
No, if you have a difficulty. you just do.
Actually, he wanted to go home, his Gwalpara.
Okay.
So he requested me to release early. So can it be?
Item number?
Item number, next item, my lord, 25.
On a request made by Ms. Anne Sekel and counsel for the paper. You are for the other side.
I'm for the APDC.
Matter is adjourned to be listed when?
10th of
10th of February.
10th of February.
What's up? Sri KP Pathak learned standing on
Can it be on the
APD
12th, your lord?
12th. You are APDCL.
APDC.
As Sri KP Pathak learned standing on the APDCL is present. Okay.
Deeply.
Two lordship, personal appearance is there, lordship. Our officer is sitting here from 10:30, lordship. Item 42, but in the cause list it is not reflected, lordship, but
Let's see the, Mr. Kotoki, just a minute.
lordship.
No, Mr. Kotoki, just a minute. We'll
Oh,
try
yeah.
to some personal appearances there. Why personal appearance? Mr. Biswas?
Because my lord, since February 2025, they are not complying with the orders passed by this honorable court.
Contempt matter.
Yes. And for on one or the other pretext, my lord, they are just delaying the process, my lord. My lord, this matter will take some time, my lord, because I'll have to apprise the court of the sequence of the events, my lord.
Yes, you are Mr. Deori.
Sir.
Yes, what is your explanation?
Actually.
Mr. Biswas, see, you may require some time to address the court.
Yes.
But since this at the stage of personal appearance,
My lord.
let us interact with the
Absolutely.
respondent officer. What is the stand? Why is the delay? Why is the delay?
Actually, when I was the director, মই delay কৰা নাছিলো। মই timely গোটেইখিনি কাম কৰিলো। কৰি পিছত যেতিয়া
The order is of which date?
Lordship, it is, yes, yes, lordship, here in this case, lordship, kindly see the order dated.
What is the date of the order?
The initial order, my lord, which was.
Yes, lordship, the order for personal appearance is 6/1.
That we have seen. What is the order?
Initial order, my lord.
Which is the order which is required to be
The date
complied
of
with?
the order is, my lord, 4/2/2025.
What is to be done?
For they had initially cancelled a tender process. This court, after, my lord, the learned single judge said that the cancellation is illegal, arbitrary, and therefore they said that the tender has to be finalized in terms of that particular NIT.
So what had happened thereafter?
Thereafter, my lord, we made a representation to them. They were, after 3 months, my lord, the director writes to the department for cancellation of the tender, which has been held as illegal by the court.
Yes.
And thereafter, my lord, the submissions were made before this court that we are taking steps to comply with this order. By next date, we'll do it. Then, my lord, suddenly one speaking order came, and that's by that speaking order, again, the same tender process has been cancelled. So repeatedly, my lord, they are violating the
Mr.
order.
Goswami, you advise your officer. This is either we initiate contempt proceeding and take action against him. You cannot sit over the judgment of the court.
Lordship,
If you are aggrieved by a decision, you appeal, file an appeal, get it
Lordship, yes,
rectified.
we has already filed our appeal, lordship. The interlocutory application for delay is.
How much is the delay?
305 days.
So where is your bona fide if you take 300 extra days to
But-
prefer an appeal And you are saying that we are not complying. First comply, then you approach the division bench.
Lordship, kindly appreciate the
See,
affidavit.
there are various kinds of contempts.
Lordship.
This is contempt which is extreme in nature. You cannot sit over in appeal and pass orders after the High Court. Will not allow you. If you do it at your own peril, we'll take action in accordance with law. We'll initiate contempt proceedings and will send him to wherever, whatever is required.
My lord, the cancel order was not passed by me.
He is not the present director, Lordship.
Who was the director?
The director is the respondent to Lordship.
Where is he? Who is he?
Lordship, he is Jayanta Kumar Goswami, Lordship. Dr. Jayanta Kumar Goswami.
We have him in the court.
Lordship, Lordship, kindly see, Lordship.
We have him in the court.
Lordship, in
He may have a good excuse that he has not passed the order, but we will have him in the court.
My lord, will just bear with me for 10 seconds.
Just a minute. We'll have him in the court.
Absolutely.
Where is he now?
Lordship.
Is he retired?
No, Lordship.
Which post is he now?
Now,
He is the director, animal husbandry now.
So he'll be in the court.
I have already transferred.
He'll be in the court.
Lordship.
My lord, the fact is not like this.
Mr. Biswas, have some patience. Yes, what is it, Mr. Goswami?
Yes, Lordship. Lordship, in the affidavit, Lordship, we filed today, Lordship. The respondent too has filed this affidavit. Lordship. In that, this affidavit, we categorically stated our steps. Lordship. We are not silent, Lordship. We are doing the process, Lordship.
But you have cancelled it.
No, Lordship. No, Lordship. This is the original order. It is page 45 in the contempt petition 58, Lordship. The para 58 onwards, Lordship. Here, Lordship, it is directed to bring the tender process initiated by the NIT dated 13/02/2025 to its logical conclusion.
Yes.
Lordship. Yes, after this order, Lordship,
Yes.
we constitute a committee for evaluate the technical bits.
Yes.
Lordship. And thereafter, after evaluation of the technical bits, some anomalies were found, Lordship. Some defects were found, and therefore, in the second step, Lordship, it is sent for the recommendation to the government, Lordship. It is
We'll do one thing. We'll have it for consideration next week. We'll consider the affidavit filed by the respondent number 2. For the time being, we'll dispense of the personal appearance of the respondent number 1. We'll be concentrating on the respondent number 2. If we find that the respondent number 2 in the affidavit explanation given is not in compliance of the order, then we'll have him personally explained.
My lord, whatever has fallen from a letter, can I just read one line, my
Yes.
lord, by the same contender? On 17th of February 2025, the contender who is present before the court, he writes, I'm reading just one line. A new committee is formed and he writes under his signature, Anil Chandra Deuri, the committee will review the judgment submitted by the Guwahati High Court White case number WPC number. How can a committee review judgment of the court? This is
inadvertent,
there.
Lordship. It is the linguistic issues. This is the language.
Mr. Deori, you are an officer, you should know what language to employ. We may still give you all the benefit of doubt that you do not mean what you have written, but that is the meaning which is coming, that you are sitting on appeal and you are thinking what to do about it. You cannot sit on review. There is a system. If you are aggrieved, you can file an appeal. There are higher courts, but you cannot say that I'm not going to comply. If you do so, you face the consequences. That is why the content of course 1971 is there.
We have promises.
Pursuant to the order, heard Sri M. Biswas, learned counsel for the petitioner, as well as Sri J.K. Goswami, learned counsel for the respondent number.
All the rest.
For the respondent's para. Pursuant to the order dated 6/1/2026, Sri Anil Chandra Deuri, Director, Animal Husbandry and Veterinary. Anil Chandra Deuri, who is presently the Secretary, Animal Husbandry and Veterinary Department, is present. Full stop. Sri Deuri has explained that presently has officer Sri Anil Chandra Deuri is present, unfortunately. Sri Deori has stated that presently he is holding the post of secretary of the department, and who's and the respondent number two is the present director. Full stop. Sri Goswami, the learned counsel, has submitted that the respondent number two has filed an affidavit in opposition today, which is tagged with the records. Full stop. Let the matter be deferred for consideration to be listed on 6th of February to consider the stand of the respondent number two. Full stop. Since the objective of this court was to have the director of the department of the director of animal husbandry and veterinary to be personally present, this court will reconsider the aforesaid direction after going through the stand of the respondent number two. Full stop. Which date we have fixed? Sixth.
With personal appearance of respondent number
Not
two?
now. The personal appearance of Sri Deori Supura Namdekeva, who is presently holding the post of secretary, is dispensed with for the present. Mr. Goswami, but do not let good sense prevail. Bring an end to the matter. Don't let it go ahead because it will go out of your hands. We don't want to set any precedent which is an embarrassment for everybody. Yes.
I'm with you.
May please, I fully endorse with the argument placed by my learned friend, from municipality board,
Year for respondent number
8 million.
or 8. Yes.
What I submit, my lord, the eligibility criteria prescribed, my lord. My only submission to that effect, the eligibility criteria prescribed. And as per eligibility certificate in respect of satisfactory completion of similar nature of work. Now, what is the similar nature of work, my lord? That your lordship will find at page 63, list of work.
Three. 3. Yes.
If I executed such type of work, my lord, then I am qualified, I am eligible to participate in the tender. And what he submitted his experience certificate, your lordship will find at page 67.
That we have seen.
That your lordship has
What
seen.
is your experience, Mr. Kotopi?
I have 2 years successfully completed, sir, in those two parts.
Which two parts? These two parts.
These 2 parts.
Including this,
Yeah.
all the equipments,
All these things.
apparatus.
Yes, yes. Existing park, and I am also running that. Now, if your lordship.
Have you formed a cartel? You don't want others to enter into the arena.
No, that,
2 years you have been running, you want to continue.
sometimes it happens, so.
And your offer was much below the offer of Mr.
But
Chakraborty.
That will come if he is very tenderer. Now the question cropped up because of Ronak, I am still relying for unsuccessful any relief at the behest of an unsuccessful tenderer is misplaced. Because he has to satisfy the court that I am successful, I have the requisite qualification, then the case would have been defined. It's not cartel, my lord. Sometimes it happens. I mean, my lord, I find it in a grid corporation, my lord, laying out electricity grid. 2-3 parties are there, not more than that. Sometimes two contractors.
See, grid, you do not equate grid with this kind of, this is a maintenance of a park.
Park.
Grid, we will require special skills. We don't need special skills for maintain a park. It's
No,
only
Milord, it's not
it's only
required.
cleanliness.
No, cleanliness and the maintaining.
Nobody can say that I can do a word of
Absolutely.
grid work without being,
I do agree with your lordship.
without being, but this is only a maintenance of park.
My lord, I agree to your lordship, my lord, but what I submit, when there is a clause, my lord, the clause once participated by tenderer, he has to accept it. My lord, clause has not been challenged here.
Let us see the annexure A vis-a-vis the NIT. How is annexure A relevant? In what context?
Annexure A part of the NIT.
Come to page 60, the contractor shall provide in the joint names of the so-and-so, so-and-so, insurance company, so-and-so, and for the following, and deductible are stated in contract data for the following events which are due to contractor's risk. Now, he is not supposed to give these items. He is only supposed to give the insurance cover.
Insurance cover.
So he is not required to, whether he is giving LED on poles or slides, that is not material. It is not for supplying this nature of work at annexure A. There is a distinction. He is only required to give an insurance cover.
Milord, what I am on, Lord, these are the equipments, these are the facilities available there.
Yes.
I have to maintain it.
Maintain it.
I have to maintain it. Therefore, what the authority decided that similar work experience must be there. That what I similarly executed.
No,
just
Mr.
work.
Kotoki, we have to lift the veil. It is not a work of executing something. It is a work of maintaining a park. Maintaining a park means cleanliness. Equipment should be informed. For that, you are not required to have an expert knowledge or skills for installation of these machineries. This clause is not applicable. This annexure which you are banking upon will not be applicable.
My lord,
It is nothing to do with the scope of the work.
at this stage, whether the scope to
No, that is not the scope of the work. You are correct in contacting the scope. The experience has to be commensurate with the scope of the work. Now, this list is only with regard to given insurance cover. Mr. Chakraborty has not argued this.
No, I know.
I have taken it in my affidavit.
Where have you stated? Let us see.
Both the affidavits.
Let us see.
First, my lord, I'll take the affidavit in reply to the affidavit in opposition filed, affidavit in opposition.
Oh, only on a rejoinder.
Yeah.
But it does not plead it in a repetition.
No, because they said that this is the requirement that I have to produce the equipments. Now, to that I have
Not produce the equipments.
I should be having the equipments. These are the annexed.
No, let us read again.
Yes.
The contractor. Please, let Mr. Kotoki complete, then we'll come to you. Please read it again.
Which one, my lord? Annexure A?
Page 60. No. The contents with regard to annexure A at page 60. The first clause. Page 60.
The
contractor shall provide. First line, page 60. Your pages might differ. You read the clause number 27.
27.
Yes.
Okay. The contractor shall provide in the joint name of the first party and the contractor insurance cover from the state from the start due to
start date
to 28 days beyond end of the operation and management liability in the amount and deductibles deducible stated in the contract data for the following events which are due to the contractor risks. List of amusement item mentioned in Annexure A.
Yes.
Loss of damage to the work plan, machinery, material, loss of damage to
Equipment.
loss of damage to property, personal injury and death or death.
So this 27 is only with regard to providing an insurance cover.
Cover. No, my lord, I agree with your lordship, but the clause is
So the
there.
projection of your defense, I don't think that will be a correct projection.
No, my lord, what I am on before your lordship. No, my lord, question is that these are the annexure items which you have handled or maintained earlier. I have to maintain it, those equipment. There must be this equipment because there's some instruments which are.
But 27 is not saying that. 27 only talks about giving an insurance cover.
No, that is contractual shall provide.
Yes.
But what is the nature of work? You have to legit, not only provide it, maintaining.
Work is cleaning those.
No, my lord, that is not the.
Brooming the park, wiping the machineries, greasing the machineries.
I do agree. I accept your lordship. What?
These are not transportation even. These are
Well,
swings,
that-
seesaws.
What I am on, that these are the equipment available there. Or these are the things available there. But whether you have the experience. And
Experience of maintaining what? A swing, a seesaw.
what
It
I
is
am
not
on.
it is not a JCB or a 8 wheeled or 12 wheeled truck.
Yeah, I do agree.
These are all simple children equipments for recreation.
When the clause is there.
No, experience would have been a valid point had it been some technical nature of job. This is only maintaining a park. He gives 57%. The Silsar municipality finds favor with you, gives at his rate to you.
No, that's.
Why
not a
so much of
favor.
love?
It can be.
Why so much of love
No,
towards you?
It can be when the negotiation always took place between the valid tenderer. Yet there are so many other judgments also that yes, authority has got the power if a valid tenderer was asked to accept this rate. That we think that our benefit, when a municipality always insisted for their benefit to earn the revenue. And therefore they offered it. No doubt your lordship, why your lordship said is correct. It's only maintenance of the park. But the criteria remains there, intact. When the criteria is there, my lord, I think that work experience required some. And today, the most interesting part too is that he himself admitted in the minutes, and he has not specifically
What is the
denied.
admission? What is the admission?
He has no experience to the amusement part. He himself.
What about the Hailakandi Park? That is not an amusement park.
No, my lord, he himself said. I have not said so.
No.
He said-
Hailakandi Park is an amusement park or not? That we don't know. We are just asking.
No, he said, what he said, he also stated that he has no such experience of running amusement park. This is all, my lord, what he admitted, and by filing an affidavit, he has only opposed it. That's the difficulty. When someone, a contractor admitted it, let me go. When my only submission before your lordship, as I am running at this stage, your lordship rightly said it is cartel. Cartel too is a different thing, my lord. A group of businessmen joined together, restricted the rate, that is Union of, that is railway case decided earlier, 1990 probably. It's a big game, my lord, wherein all the companies join together and fix it, that we will not go beyond that. That's cartel. Here is a simple maintenance case, my lord, of a part. There is no cartel here.
Simple maintenance, he is also equipped.
No, my
to
lord.
To do a simple maintenance.
Absolutely. He has also right, but he himself admitted, and he said that had it been known to me, I would not have been participated earlier. That type of statement, my lord.
Let us see the experience clause. What is the requirement of experience again?
Page 60, my lord.
Page 57.
57. Sorry.
Serial number 5. Certificate in respect of satisfactory completion of similar nature of works under government, semi-government department during last 2 years along with work order. Tenderers may have completed same nature of work at least one number in single work order in the last 2 financial years under so and so.
It has to be for 5. Similar work means work of 5 years, my lord.
No. Cannot. Duration is not similar. Is not nothing to do with duration. Similar is the nature of the work.
And nature of work, my lord, nature of work for particular.
And he has an experience of 6 months.
That cannot be equated with the that too a small part, my lord, that too a.
Let us see again. See the minutes of
There are many minutes, my lord. First minute start at 30, page 68 on 31st of July. They got it and they decided to verify the experience certificate. Second minute on 19/8/2024.
no, the actual decision was taken in 69. Is it 19/8/2024?
Yes, ma'am. No, that's it. He has less experience in maintenance of part facilities, shows the tender has less experience to run similar part under Silchar Municipal Board. We have paid fairly, my lord, when the authority paid fairly, giving opportunity to.
Don't say we.
No, my lord. Suppose.
You are a beneficiary.
No, my lord, what I am on, that it is not that case that we straightway reject his case, we gave him opportunity. When the authority gave him.
Again, we. You are the beneficiary. Now the connivance is showing in the court. Your connivance is showing in the court. It's being reflected in the court proceedings. Beneficiary is the decision-making person.
Connivance is not there. Always, private and the government join together to fight it out. That's not connivance. It's connivance more very dangerous word. So therefore, what I submit before your lordship, prima facie, a clause is there, and clause unchallenged is still intact. And my humble submission before your lordship, there may be some mistake, my lord, small mistake. That cannot be a blunder, my lord. Treated as a blunder. It may be a mistake, my lord, on the part of the authority.
Mistake, which mistake?
Maybe what?
Here in this case, which act of the authority you are?
My lord, here I am, what I am find, the authority opened the tender, price bid. That's one of the mistakes. Because when you two bid process, you cannot open. That's the one of the mistake. Otherwise, his right would not be. Otherwise, I would have entitled to enjoy my own right. Now the authority, that is the one mistake. When they accepted the thing that his tender is not, he failed to fulfill the prerequisite criteria, he automatically, his tender is liable to it without opening, without going to that extent. Therefore, my humble submission, the fairness of the authority is clear, without giving opportunity. To justify his experience before the tendering evaluation committee. And that's, in that context, Shilpi construction paragraph 19 is, I am relying that your court has that 19 and 20. Court.
Yes.
Here is my humble submission that there is no irrational, arbitrary action on the part of the authority. Neither anything brought before your lordship by us.
Yes.
And therefore, my humble submission, your lordship, that the petitioner failed to satisfy the eligibility criteria, and accordingly, authority rightly rejected his tender and granted me. If your lordship held that the eligibility criteria.
Mr. Kotoki, what is your name?
My name is Mondol.
Where is your discussion?
Beg your pardon?
Where is your discussion regarding you being held to be qualified?
Yes, ma'am. Page 70 minutes.
70.
First, second, third, fourth paragraph.
Okay.
That's my humble submission before you.
Yes, Mr.
My lord, so far, the requirement in clause 27. My lord, to that, my lord, my response and my rejoinders to the affidavits oppositions filed by respondent number 6 and 7, that is the municipal board, as well as to the affidavit in opposition filed by respondent number 8. If your lordship kindly takes up to that specific aspect. Now, if your lordship takes up page number 84.
Yes.
If I take your lordship to the
84 is your reply affidavit.
This is my reply.
Part of the reply affidavit.
This is my reply affidavit to the affidavit in opposition filed by respondents number 6 and 7. Page number 84, your lordship has got it.
6 and 7 are the tensor.
Municipal board.
Okay.
Yes.
Yes.
Page 84, your lordship has
Yes,
got.
yes, we have got it.
From below, if your lordship takes up the fourth line above, from below.
Yes.
At page 84.
So far.
So far, the requirement of clause 27 of the NIT dated 22/7/2024 is concerned. The annexure A, as mentioned there, is not about submitting any list of equipments as sought to be projected. It is rather the insurance cover of the amusement items as mentioned in the list annexed as annexure A to the NIT, which was required to be provided by your deponent, and that too after the acceptance of the tender and not at the time of submission of the technical bid. Your deponent was absolutely ready to provide such insurance cover from the start date, which however never came as because no work order was issued in favor of your deponent. This is in response to the affidavit in opposition of respondent number 6 and 7, and same same contention having taken by respondent number 8 in their affidavit in opposition, that too has been responded at page 93, paragraph 5, the sub-para at page 93. My lord has got page 93.
Just a minute, please. Yes.
Now, 93 sub-para, my lord, of paragraph 5 is the same contention. So far, the requirement of clause 27 of the NIT dated 22/7/2024 is concerned. The annexure A, as mentioned.
93 paragraph?
This is paragraph 5.
Or second paragraph?
Second, yes, ma'am. So far, the requirement of clause 27 of the NIT dated 22/7/2024 is concerned. The annexure A, as mentioned therein, is not about submitting a list of equipments. It is rather the insurance cover of the amusement items, as mentioned in the list annexed as annexure A to the NIT, which was required to be provided by a deponent. That too, after the acceptance of the tender and not at the time of submission of the technical bid. Your deponent was absolutely ready to provide such insurance cover.
Yes, yes.
Now, regarding, my lord, the scope of judicial review in contractual matters, in tender matters, which my seniors have placed before this honorable court, and I'm grateful for that. Now, in AFCON, in Agmental, and in other rulings of the Honorable Apex Court, the exceptions which have been pointed out is malafide, perversity, and if it is favoring someone. These are the three exceptions which have been pointed out, lest which there won't be judicial scope of judicial review insofar as contractual matters are concerned. Now, my lord, to press upon the aspect of perversity, your lordship kindly takes up one aspect of the matter that also I have rebutted. Now, in the affidavit in opposition filed by respondents number 6 and 7, and which has also been argued by my senior on behalf of the municipal board, your lordship kindly takes up paragraph number 5 of their affidavit in opposition forward. Paragraph number 6 at page 49. Page 49, paragraph number 6.
Affidavit by the spot number 6 and 7.
Yes, ma'am. At page 49, if your lordship. Page 49,
Yes.
paragraph number 6. May I read this paragraph?
Yes, please.
The respondent number 6 and 7, in order to get the clear picture in regard to the precise quantum of land area along with the list of equipments, requested the Executive Officer, Hailakandi Municipal Board, via its letter dated 1/8/2024, to furnish the details of the quantum of lease area along with the list of equipments installed therein. The Executive Officer, Hailakandi, via its letter dated 3/8/2024, informed the respondent number 7 that the quantum of lease area is 1500 square meter, and equipments installed are LED lights with pole, visitor sitting arrangement, whereas Gandhibagh Park and Norsingtola Park consists of 6400 square meter, and equipment installed as in clause 27 annexure A in the NIT dated 22/7/2024. Therefore, the equipment mentioned in annexure A of NIT clause 27 does not justify with the items mentioned by Hailakandi Municipal Board. Now, if my lord, if I may trouble your lordship with the NIT for a while, my lord. In my writ petition, I have annexed it at annexure 1 at page 22.
22. Yes.
Now, the notice inviting tender, the very first paragraph may I read, sealed tenders are invited on percentage basis of the revenue generated by the undersigned from the eligible category registered contractors of Silchar Municipal Board with or without APWT buildings and roads or nationally reputed firm for the operation and maintenance of the Gandhi Bagh Park and Norsingtola Park. Now the pertinent thing, area 400 square meter approximately. So now, having participated in the tender process pursuant to this notice inviting tender, whereby the operation and maintenance was supposed to be only for an area of 400 square meter, that is as per their notice inviting tender. Now, what I am given to understand is that having had an experience of maintaining a botanical park of 1500 square meter, I fall short because the area of the two parks now is assessed to be 6,400 square meter on paper, and that is where I fall short according to the authority. That is where I am disqualified, having not maintained this big a park. My limitation is up to 1500 square meter regarding the Hailakandi Park. Now, in the notice inviting tender, the apparent perversity is that they invite a notice for maintenance and operation of a park of 400 square meter.
Yes.
And I have given an experience certificate of 1500 square meter. And now comes an affidavit where the area of the park in question is now said to be 6,400 square meter, and I fall short of my experience to maintain this big a park. And therefore, this comes as a reason for my disqualification. And my lord, my third and the most important claim of argument here would be in regard to the procedure in which I have been ousted. After having opened the financial bid, 57% H1 rate, I was asked to submit my tentative plan, which I did. Thereafter, I was invited before the tender evaluation committee along with my rival, and there I was ousted and I was replaced by respondent number 8, giving him an opportunity of increasing his rate from 35% to 57%, in which also there has been a bargain. The respondent number 8 has come up with a request of reducing it from 57 to 50% so that the 7% can be utilized in the betterment works, and perhaps that might also have been exceeded too. So this is, my lord, in short, my case, where I have been done in so far as this procedural irregularities, and if I may say so, illegality. That is my case.
What is this 400 meter? Can you
No,
explain?
that is, yes, my lord. My learned friend, possibly he could not get the idea. Now, your lordship kindly see in the bracket, area 400 square meter approximately, excluding the area allotted for cow gullies. This is the excluding area for that purpose. It's not that the area is only given 400 square meter. It's a total misconception on the part of my learned friend. And what he has stated, your lordship, can
Any other materials from where we can, at the inception, where we can get the get an idea?
I have given in my affidavit.
No. From the inception and the document.
In the document.
Document where.
No, in the document, except this, my lord, there is no other. But then I have the instruction, my lord. After seeing this, initially it came to my mind also. Then they have clarified that the area is 6,400 square feet and square meters. Sorry. Now, what is the averment he made in his, my lord, your lordship? Kindly see at page 85, para 7. That as your lordship got that. As regards the statement made in paragraph 6 of the affidavit in opposition.
Yeah, we've read this. Yes. We've read this. 406.
No, what he's saying,
Yeah.
that, my lord, the last line, your lordship kindly see. Your deponent, then aware of that, the quantum of lease area is 6,400 square meter instead of 400 square meter, as depicted in the NIT itself, your deponent would never have participated in such tender process. That means you are saying that if it is only 400 square meter, in that case only I can compete, otherwise not. That means he is not capable of doing that. That is own admission. Now, if you are not able to do that, why you participated? He must have went in that place. Gandhiba is a big area. He has seen it.
I'll respond to this. This also I'll clarify now.
Now, this is one thing, my lord. Now, he is blowing hot and cold. Now, your lordship, and next, my lord, I want to clarify at page 69.
69 is.
Just I will read the first paragraph, my lord.
69 is.
The first and foremost executive officer Silchar Municipal Board apprised the House regarding the decision adopted in the meeting held on so and so. As regards to that, the authentication letter number so and so issued by the Hailakandi Municipal Board has placed before the House. The executive officer Hailakandi Municipal Board has verified.
This we have read.
Yes, yes, well, at the cost of repetition.
No. Which part we want to?
Now, however, in NIT wide number dated so and so in clause number 27, Silchar Municipal Board had enclosed a list of equipment as Annexure A.
We have read this. We have read
Which
this.
are now, I just want to buttress the thing that your lordship kindly see what is there in the Annexure A. Now, you were to the natural, my lord, instinct of the person is that he must have done that sort of work, the nature of work. Now, there some LED light and some chairs, everybody can place it there. Now, he has run a small park, my lord, it's not amusement park. There is no other.
But he is not required to install these equipments.
Your lordship
It's
is
only
right.
maintenance.
Exactly, my lord. But then this person must have the experience of doing that.
What are these materials? Are those highly technical materials?
No, your lordship.
These are
did it.
springs and seesaws and chairs.
Lord, apart from that,
We
my
cannot
lord,
be so technical.
No,
We have to leave the veil and see the situation.
that is always there.
It's a
but
park, children's amusement park.
My lord, lifting the veil in the appropriate case.
Now,
it's
what are the
always
nature of the
your
equipment? It's not some roller coaster that you need
Very- very right.
technical expertise.
But then,
Normal swing, seesaw, and all those things.
yes, yes. But what he's saying now, had it be, if I known it that
Yeah,
6,400 square meter,
that we have noted.
then I would not have
That
gone
we
there
have-
itself. So therefore, it is their admission, and then he has again said that I do not have experience of running the amusement park. On the face
Okay,
of
well,
all
then
that,
we have considered.
therefore, my lord,
Okay.
on the face of all that, my lord, lifting of veil, possibly, my lord, I don't say that your lordship cannot do that. In appropriate case, definitely court has the power. But then in such a situation, my lord, I say that it's not.
Okay, we'll
where-
consider, we'll consider.
Ma'am,
Heard. We, the Chakraborty, Learned Counsel for the petitioner also heard. The state is there, Mr. Also heard. M. Ketia, Learned State Council, comma, 3 S. Datta, Learned Senior Counsel for the response number 6 and 7.
6 and
7, assisted by Ms. M. Musari, S. Musari, and Sri S. Kotoki, Learned Counsel for the response number 8. Full stop. The hearing is concluded and judgment is reserved.
much obliged.
Deeply obliged.
Seven. The.
May I please, your lordship? Lordship, the matter, lordship, the respondent authority is supposed to file their affidavit as per the last order. The lordship, actually the matter pertains to lordship, the petitioner has challenged the penalty order which has been issued by the respondent authority. Lordship, after 9 years of giving me the completion certificate, I have executed a work, lordship. They have duly served me with completion certificate. Lordship, after 9 years, expiry of 9 years in the last 2024, lordship, they have issued a penalty order for delay in execution of the works, your lordship.
Yes, madam, you're for whom?
And for all the respondents,
Yes,
we have received the instruction. We need 4.
which is a new matter.
Lordship,
It's a new matter, 25 matter.
2025, yeah, lordship.
Okay, notice was issued.
Yes, notice was issued, your lordship, and lordship, interim order is also operating, your lordship.
What kind of interim order?
Lordship, they have already forfeited some amount of money, lordship. It is reflected in order
Okay.
dated 16/6/2025. Lordship, there is an interim, your lordship.
Okay.
20 out of 28 lakhs 34,000.
You're Mazumdar?
Yes,
What?
miss.
H. Mazumdar?
H. Mazumdar, your lordship.
First for H. Mazumdar, Leonard Counsel for the petitioner. Madam, your name?
Escort.
S?
Escort on behalf of SS Roy.
Also heard Miss S. Cor Leonard Counsel appearing on instruction of Sri S. S. Roy Leonard CGC, who has submitted that instructions have been received.
Received, but it's in process, but we need 4 weeks more time to do.
Received, and the affidavit would be filed for which she has paid for time. Para? Matter accordingly stands adjourned to be listed on 23rd of February, by which time the affidavit in opposition is required to be filed.
Much obliged.
Interim order passed earlier to continue till the next date of listing.
Deeply obliged.
I didn't have the.
3-0. M. Ahmed, I. H. Laskar. PNRD. Madam Bora. None appears for the petitioner on call, whereas Miss N. Bora, Learned Standing Council PNRD is present. Para, in the interest of justice, matter is adjourned to be listed on 6th of February. Para, interim order passed earlier to continue till the next date of listing.
Lordship, in this case, we have already filed our affidavit.
Also, who has submitted that affidavit in opposition has been filed. Again, Bora কথা বুঝলি?
Lordship, in this case, we have already affidavit sent for vetting. So kindly
Okay, yeah. How much time? 2 weeks?
fix them.
Okay. Your name?
Yu Khan.
Yu Khan, are you there on record? Yes. Heard through Yu Khan, Learned Counsel for the petitioner. Para. Also heard Miss N. Bora, Learned Standing Counsel, PNRD, who has submitted that the affidavit in opposition has been prepared and sent for vetting. He accordingly prays for some time to file the same. Para. In view of the above, matter is adjourned to be listed on 13th February, by which time the affidavit in opposition is required to be filed. Yes, next.
For the respondent number 5, we have prepared the affidavit and sent for.
Who is filed?
I'm my lord, general manager, my lord.
What is your name?
SK Saha.
Heard Sri S.K. Saha, Learned Counsel for the petitioner. Para. Sri M. Chetia, Learned Counsel appearing for the State Council.
Yes, my lord.
State Council appearing for the respondent number 5 has informed that the affidavit in opposition has been prepared and sent for vetting. Full stop. He accordingly prays for. And is full stop. He accordingly prays for some time. Para. In view of the above, matter is adjourned to be listed on 9th of February, by which time the pleadings may be exchanged. Sri M. Bhuya, Learned Counsel for the
For responding numbers 1 to 4.
Health Department.
No, Lordship, this could be the.
Industrial commerce.
As well as the industries commerce.
For the Industries and Commerce Department is present.
Sure, I have a small prayer. Can it be taken up any date after 9th of
You
February?
tell us, 11th? 11th.
Lordship, regarding this. Lordship, after 15th, Lordship.
Any, then 15 will say, then we'll say after 16th.
Can it be taken up on?
Have a
9th?
fixed date, 16th. 16th.
I beg to apologize, but regarding these matters, we also have to file a.
We have said for exchange of further pleadings.
Highly obliged. Much obliged.
By which of further pleadings may be exchanged, sir? He lost can you put it? This consensus, by which time further pleadings may be exchanged. Huh? This consensus, by which time further pleadings may be exchanged, sir? Yes. Mr. Goswami.
Lordship, I'm a contractor, first class one contractor. I have executive work and competitive work. Thereafter, without my knowledge, without cancelling my tender process, they have issued their work to different person and made the payment. And Lordship has directed to not to make any payment. That order was communicated to the authority immediately after the order. But thereafter, after going to the information also, they have released the amount. That is why I have had to file contempt petition.
You have filed contempt?
Lordship.
Where? Oh, this one, the other one, okay. Now, what is the stage now?
Contempt petition, they have stated that the order was received by the authority before release. But the person who has received the order from this honorable court, she has left the order in the drawer, and thereafter she could not communicate the order to the authority. And that is why authority without knowledge released the payment. But according to me, I have filed the reply. I have communicated the order, not only to the executive engineer, to the other person also. And executive, I have.
But Mr. All said and done, Mr. Upadhyay, after knowing what steps have been taken?
Lordship, no.
It was in the drawer.
Lordship.
It was in the drawer kept by one of your officers.
Yes.
You came to know thereafter.
Lordship.
After knowing, what did you do?
Lordship.
Did you withdraw the amount? Did you revoke the order?
The order was not.
Then it is a fact that it was served upon you for the negligence of your officer. You have taken the defense that you did not know about it. But you came to know. You cannot find fault with the petitioner that he is not served with a copy. What steps did you take?
In the meantime, Lordship, the money was released. The respondent
Should have again recovered the money from him. Which department? Water, irrigation.
In the meantime, this person also retired from service, Lordship. The contemner, Lordship.
Against whom, Lordship, the party has filed FIR for the not this petitioner. Other has filed FIR. They have approached this court for anticipatory bill that also rejected. I have annexed. That same officer.
Not the
Now in the writ petition, what has happened in the writ petition?
With petition, Lordship, the BT.
Now writ petition has become almost infructuous. He has to fight for damage now in a civil court. Even if he makes out a case, what relief can we grant him? Nothing. And that is the objective of having an interim order passed in matter of this nature, that this cause of action stays alive. Now the cause of action is gone. Affidavit exchanged. Yes, we have it next week. Heard Sri S.K. Goswami, learned counsel for the petitioner. Also heard Sri N. Upadhyay, learned standing counsel irrigation department, and Ms. B. Bora, learned standing counsel BTC. Para pleadings have been exchanged. Para list for admission hearing on 10th of February.
Lordship. Obliged.
Yes, Mr. Bonik.
May it please the Lordship.
53.
Well, I'm challenging the tender conditions at page 22.
You are challenging what?
The tender conditions
Okay.
at page 22.
Who's for the state, Mr. Chetia?
I must inform you now that so far as this matter is concerned, the state would not have so much of role so far as the other two, and we have served dusty on them, and I'm under interim protection also.
Who are the other two respondents?
Other two, no, I don't think they're represented.
Now, who are the?
Adarsha Vidyalaya Shangarsha and the director of that institution, my lord.
Mr. Gogoi, are you appearing?
See, I am appealing for one only.
One would not have much of a say.
We have no role also.
They would not have much of a role.
Who are these two and three?
The Adarsha Vidyalaya Shangathan, my lord.
It's under the central government.
No, they operate under the education department. But only thing is the higher education, and so far as they're concerned, but it's still
Adarfa
issued by
Vidyalaya Sangharkha. Yes, education department council will be representing them. Can you have any education council?
No, sir. I am representing the higher education department.
Or then I think you can appear. Can you appear? Take instructions?
Lots.
We are not very sure about this kind of the organization.
On the last week,
Is it under you, under the department?
Say independent also. I will try to contact them.
Now, if it is independent, then is it a creature of a statute or what?
Probably that part I have preference.
Now, how is it maintainable?
because it is through the department, of course, they operate on them. They
No, he
operate
said
on-
that is not under the
No, no,
department.
no. They, so far as the issuance of the tender is concerned, I'll just invite my lord's attention to page 12.
Well,
Page 12. Independently, they are inviting the tenders, but they're under the department. Would my lord come to the fourth point, 1, 2, 3, 4, fifth point, education department name.
I think Mr. Gogoi, perhaps you can, education
madam.
department appears to be the parent department. You take instructions, okay?
I'll take it. Otherwise, then also it will be another school education. I will obtain stuff.
Another?
Another school education. I will obtain stuff.
On the last occasion, this matter was looked into. It might not have the looks at 17 November 2025 order. Although we had indicated higher education, it was taken to be education department.
Can we have any, do you have a council for education department?
No,
School
also we have the school education and higher education also.
School education, anyone is
School
there?
education is comprising elementary and secondary.
Okay.
Next, they also may give.
Yes.
I-
Okay, heard. Sri S. Bonick, learned counsel for the petitioner. Also heard Sri K. Gogoi, learned state counsel, full stop. On the, with regard to the representation of the respondent numbers 2 and 3, who have been served, comma, Sri Gogoi, the learned state counsel, who also represents the higher education department, he is directed to obtain necessary instructions. Full stop. List on 9th February, Monday.
The interim protection to continue.
Interim order passed earlier to continue till the next date of listing.
I pay for a copy of the.
Give a copy.
The Devoto matter.
33. This can it be disposed of?
Gotcha.
You have a similar order?
Yes, sir.
Yes, what is your name?
Jay Hatimuria.
Jay Hatimuri. We'll dispose this off in the terms.
Yes, sir.
Please you have a look, Mr. Hatimuri, have a look at the order. Jay Hatimuria, A. Ali. For election, madam, you are for whom?
Order number 6.
For respond number 10, Lord.
10, who is 10?
Superintendent of Police, Baksa, Lord.
Oh, okay, your BTC council.
I'm for
FTN.
Oh, you are FT on, you are a standing council on behalf of Mr. Pang. Yeah, okay, what is your name? As Dore on behalf of J Pang, standing council, FT. Okay. And, Mr. Ali, please make the order, correction with pencil and both of you submit jointly, okay, disposed of. Nambila likhi so na?
Yes, Mr.
Kindly
Sharma.
see the last order, my lord, 3/9/2024. It's a long time back. It's A. Bhagavati 4-3, respond number 345, took 2 weeks time to file affidavit of opposition. Today also he is absent.
A Borpujari.
A proposal, yes.
Who is A Borpujari? A Borpujari কোন আসলে? A Borpujari. Some tourism. I think tourism presently is tourism. Oh, this is ATDC.
Yes.
We had some council in the morning. ATDC tourism. Who was there? One lady. Huh? Oh yes. Oh, she appears on a case-to-case basis. P. Bora, Madam P. Bora.
But here I think A proposal is appearing.
Who is A Borpujari?
I forgot his face. I think last time I saw him.
Hey, ready to sound? নাম দেখাইছে নাকি এটা? Names are shown, Mr. Sharma.
Yes, just wait.
Name also not shown.
Yes, yes.
But vocal numbers also not shown. If there is a Wakalat Nama, we'll direct a listing of this case
Yes.
by reflecting his name. Otherwise, you can just contact Madam P. Borwa. Is it? Say, huh? Dilag nai? Yeah, no, dilag. Wakalat Nama, sir, Wakalat Nama. তলত থাকিব পাৰে এখন নহয় এইবিলাক তলত এখন পেটিশ্যন হৈ গ'ল আৰু এটা ফাইল আছে নহয়
আৰু এটা সেপাৰেট ফাইল থৈ
What is your cause of action, Mr. Sharma?
Your Lordship, there's a Prasanti Wayside Amenity Center. That
Where is it?
It is Biswanath Sarali.
Okay.
That was allotted to petitioner. So he was running, and there was a my lord acquisition of land because of the national highway, my lord expansion of national highway.
Okay.
And there's a there was a Assam type house constructed by the petitioner, and some trees was also planted. So because of that trees and that Assam type house, a compensation was assessed and paid to the petitioner. Now tourism department is claiming that we have defrauded this tourism department by in nexus with the Lat Mondal and a Gabura. This land is a government land, is a habitat fact. For the land, compensation was not given. For the Assam type house and the trees, compensation was given. And now even if there is any, my lord, objection to that, they have a, my lord, separate forum is there. They have lost their FIR.
Can you inform me, Miss, because we do not find an official
Yes, your lordship.
power in favor of Sri Borpujari. He must have appeared on some instructions, but there is no power. And since there is no concept of standing councils for the Tourism Development Council, or tourism, what is it? Tourism Development?
Yes, sir. Some
Corporation.
Development Corporation.
Heard Sri M. Thermal Learned Counsel for the petitioner, as well as Sri M. Chetia, Learned State Council. Full stop. There. On the last occasion, that is 3/9/2024, Sri A. Borpujari Learned Counsel had submitted that he had entered appearance on behalf of the respondent numbers 3, 4, and 5. Full stop. However, the said respondents are not represented today. Full stop. Perusal of the records have not revealed any power being filed by the Learned Counsel Sri Borpujari for the said respondents. Para. In view of the above, matter is adjourned to give the respondent numbers 3, 4, and 5 a further opportunity to appear. List on 11th February Please inform Ms. P.
Highly
Bhagwan.
obvious. Highly.
Mr. Roy?
As per the office note, my lord, dated 19, Laozima order, my lord, 19-1. I find the notice on respondent number 2 and 3 has been served, my lord, on 26/12/2000.
You are appearing?
For the respondent number 1.
One.
My lord, in fact, though it is received on 26/12 only, so since their presence would be required, because they are the employees union who made a complaint that they did not get the
Third
ticket.
Sri P.K. Roy Leonard Senior Counsel assisted by Ms. Chakraborty, A. Chakraborty, for the petitioner. Also heard your name?
W. Rahman on.
W. Rahman on behalf of A. Sharma on, for the respondent number 1, corporation. Para. Peruse the order dated 19/1/2026 passed by the learned Laozima Court, as per which service upon respondent numbers 2 and 3 has been held to be complete. Full stop. The aforesaid note is accepted. Full stop. To enable the said respondent numbers 2 and 3 to represent, matter is adjourned to be listed after 2 weeks.
Lord, that's better. my lord.
We give a date. We are supposed to give dates on
It's
it.
better.
We list on 13th,
13th, my lord.
or we can have it on 16th.
16th. Oh, my lord, I'll not be here. Let it be 13 or after
Complete
that.
on 13th. We'll be there, not on
Oh.
16th.
On 16th, my lord, not 13th.
Whenever you say.
13th or anytime after 16th. 13th is okay.
10:26. Mr. Laskar?
Please, Your Lordship. As per the last order, we have served a copy on I. Bhattakur, advocate for.
Yes. Yeah, 2020 matter. You are newly implemented respondent number 3. Who is the newly implemented respondent number 3? Who name? What is department? Council. What is department officer? Pre R. Google Leonard Council appearing for the newly implemented respondent number 3 has prayed for some time to obtain instructions, file affidavit of opposition. Para. Matter accordingly stands adjourned to be listed on 18th of February. Obliged. Item 38. 38. Yes.
Lordship, in this matter, Lordship, it has to, actually, it has to come for admission. Lordship, service is completed already. I am appearing for respondent 4.
4. You have filed affidavit.
No.
Would you like to file affidavit? Who is the respondent number 4?
The executive. Executive officer. Young municipal board, the executive officer. Municipal board.
Okay. The respondent number 4 has entered appearance through your name
K. Bhattakur, on behalf of KL.
on behalf of
KL Gupta.
KL Gupta. Your name?
K. Bhattakur.
K for the Dhing Municipal Board.
Executive.
The executive officer is so and so
Dhing Municipal.
of Dhing
Municipal Board.
Board has entered appearance through Sri K. Bhattacharjee, appearing on instruction of Sri K.L. Gupta, Learned Council. He prays for and is granted 4 weeks time to file, 23 minutes, 3 weeks time to file affidavit of opposition. List on 18th of February.
I'm obliged.
Item 40. Item 40. None appears for the petitioner on call, whereas the Learned State Council is present. Para, in the interest of justice, matter is adjourned to be listed after 3 weeks.
May I please, Your Lord? On dated 1/12/2025, it was regarding for the update of the financial section.
Yes, Mr. Gogoi.
Lordship, there was a query from the department to the executive engineer, and the executive engineer has written back to clarifying the query, Your Lordship. So we were sometime we give, because already the financial proposal has been sent, Your Lordship.
Okay. Sri R. Gogoi Learned Counsel appearing on behalf of the
PhD department.
PhD department. PhD department has informed that certain progress is on and that certain steps are being taken towards compliance of the order in question. He prays for and is granted 4 weeks time to get further instructions for a list on this 29, list on 25 2. 25 2.
Okay. So is this case I'm referring for reference number 2. I took some time to file a little bit, but technically, the direction, in fact, in the petition, he has said, if paragraph number 7, if Lordship takes up paragraph number 7 and paragraph 11, the Deputy Commissioner Morigaon is required to pay it. The office note of 6/1/26 reveals that the notice is not yet served to the Deputy Commissioner. In fact, for the respondent number 2, my instruction, I have received some instructions, I need some time to file with my affidavit. The instruction says that the SP has already taken up the matter with the Deputy Commissioner, because all these types of payment are to be made by Deputy Commissioner. It is the case of the petitioner also in para 7 and para 11 of the petition. So the notice on respondent number 4.
You are for R2.
I'm for.
3 and 4 yet to be served.
Yes.
3 and 4 was notice was issued on 8/9. Mr. Sharma, you have to take fresh steps. 3 and 4, and in the meantime, Mr. Nath appearing for the respondent number 2 would file the affidavit.
Yes.
Okay.
Office note of 6/1/26 is there. Regard has done
That we have said.
He has to fix space.
No, the steps were taken way back on 8/9/25. So now the question of a month that has elapsed long time back. Heard Sri N. Sharma, Learned Counsel for the petitioner. Sri D. Nath, Learned Counsel has entered appearance for the respondent number 2 and has paid for time to file the affidavit of opposition. Perused the office note dated 8/9/2025. Perused the office notes, including the one dated, including those dated 8/9/2025 and 6/1/2026. Full stop. As the aspect of service of notice upon the respondent numbers 3 and 4 is still uncertain, Sri N. Sharma, Learned Counsel for the petitioner, is directed to take fresh steps for service of notice upon the respondent numbers 3 and 4. Steps be taken by Speed Post to TD within 2 working days. List on 27th of February, along with fresh service report.
Yes.
May I please, Lordship? Also, with the apology, my lord, when item number 40, when was matter was called for, I was in court number 2, my lord. Item 40, my lord.
We have passed orders, you should be there, somebody has to be there. What orders did we pass?
My lord, none appeared, my lord, 3 weeks later, my lord.
None appears to ridiculous, but we cannot record your presence after the matter is over. We can remove the none appeared.
My lord, that's all I want, my lord. Most probably. My lord, my name is.
We cannot be record your name. You are not present when the matter was called. We'll try to remove that none appears part.
My lord, my lord.
Yes.
My lord.
That's very much. So I am appearing for the Vilasipara Municipal Board.
Okay.
As well as the toll contemner, who is the executive officer of Vilasipara Municipal Board. Meanwhile, the order of the honorable court has been complied.
Do you have a copy? None appears for the petitioner on call, whereas the Empathok, Learned Counsel, has appeared for the respondent numbers.
Toll contemner,
For the sole respondent. For the sole respondent. Full stop. Sri Pathak, the Learned Counsel has submitted that the order in question has been duly complied with, and in this regard, he has placed before this court copies of the communication dated 21/1/2026 issued by the Bilasipara Municipal Board as well as the minutes of the meeting dated 16/1/2026. Full stop. It appears that the order dated 9/12/2024 passed by this court has been substantially complied with. What was the order? Are substantially complied with, which pertains to consideration of the case of the petitioner. Para. The contempt petition accordingly stands closed. Copies of the communication mentioned above are made part of the records. You have extra copies of this? Do you have extra copies of this? Yeah.
I have.
Yes, Mr.
This matter was listed before your lordship on this Tuesday, lordship.
Okay.
So on that day, I had no instruction as such. Order could not be transferred by your lordship. This is a implement application.
Implement.
Implement, lordship.
We can allow the IA. IA is what? What IA for?
Implement.
Okay.
Of
Heard your BP Sharma.
lordship.
Heard Sri BP Sharma, learned counsel for the applicant petitioner, who by means of this application has prayed for implement of the following incumbent as the respond number 3. Incumbent to Likhiriba, huh? Page 8232. Page 8232 Likhiriba, huh? He has submitted that the party proposed to be implemented is a necessary party whose presence would be necessary for a proper adjudication of the lease in hand. Para. Also heard Sri K. Gogoi learned CGC, who does not object to the aforesaid prayer. Para. Considering the facts and circumstances, and also the aspect that the party sought to be implemented is the necessary party, comma, the instant application for implement is allowed. Full stop. Allowed. I stand disposed of. In the main writ petition, right? Wide an order passed today in IA number so and so. Implement of the following entity has been allowed as respond number 3. Entity naam likhiriba. Sri BP Sharma, learned counsel for the petitioner, is required to file an amended cost title within a period of a week. After filing of the amended cost title, matter is to be listed before this court for issuance of notice upon the upon the newly implemented respond number 3.
Deeply blessed.
Madam Devi?
Madam, I have filed one affidavit, my lord, in pursuance to the order dated 17/12/2005.
Affidavit for?
Okay, for taking justice service. I have already been taken. Twenty-seven is the order, 17/12/2025.
Yes.
Yes, sir, 2 and 3. Oh. No, I didn't like my digging. Wait, connected one. No difference.
heard Ms. K. Devi, learned counsel for the petitioner. Also heard Sri K. Gogoi, learned state counsel para. Ms. Devi, the learned counsel has submitted that pursuant to the orders passed by this court, dusty service upon the respondent number 1 has been affected, and in this regard, an affidavit has been filed on 21/1/2026. Peruse the said affidavit, full stop. Peruse the said affidavit with which the petitioner has enclosed the acknowledgement or receipt of the copy by the respondent number 1.
No, one.
1.
One of these, 4 is by speed post. I have already been taking steps. Other to push up.
But no, it's 4, madam.
4? I'm sorry.
It should be 4. Why have you written 1? Why have you written 1?
Yes, madam. May I correct?
No, কি করবো বলো?
Hey,
উপর। Oh.
correct. না, করে দিব। তুমি ঠিকই করছো। Yeah, well, it's wrong.
Huh. 4 has been Miss Devi has, however, submitted that in the affidavit filed, instead of respondent number 4, due to inadvertence, respondent number 1 has been written, full stop.
Yes.
However, on perusal of the affidavit, along with the enclosures, it appears that is the respondent number 4, which has been served in terms of the order passed by this court. And there is also an acknowledgement of receipt in view of the above, service upon the respondent number 4 is held to be complete. List this matter after 4 weeks to enable the respondents to file affidavit.
Can it be fixed a date
Tell us.
after 4 weeks?
List on 27.
Yes, highly obliged.
2. What are you?
Sorry.
What was it? Huh? What was it? Hearing. M. Sharma. M. Sharma Ashirel. Yes, madam. What was it? Oh, we
Yes,
had.
yes, lordship. Today it is for disposal, lordship.
Okay. Sharma was there or not?
No, lordship, he is not there. Out of
In
station.
the morning he was there.
Yes, lordship. He went to Jorhat actually.
Oh,
in
can
the
we
afternoon.
record your name, madam? You are Yasmin.
Yes, Yasmin.
Heard Miss S. Yasmin. Learned counsel for the petitioner. None appears for the respondents on call. Full stop. When this matter had come up for consideration yesterday, the learned counsel for the petitioner had submitted that this matter is squarely covered by a decision of the Honorable Supreme Court. Full stop. For any reference, the order passed yesterday is expected herein below. Full stop. As reflected above, even today, there is no representation on behalf of the respondent numbers behalf of the respondents. Full stop. The grievance of the petitioner, which is a nationalized bank, is with regard to is it an order? Is it an award?
Yes, lordship.
Is against an award dated 22/5/2015 passed by the Learned Industrial Tribunal cum Labor Court in relating to a bipartite settlement. Two bipartite settlements dated 26/2005 and 27/4/2010. Full stop. The same pertains to engagement of armed security guards. Full stop. The learned counsel for the petitioner has drawn the attention, has placed reliance upon the aforesaid judgment of Deputy General Manager, Union Bank of India, Ragat Supra, wherein the Honorable Supreme Court has settled the issue. Full stop. For any reference, the relevant observations made by the Honorable Supreme Court are extracted herein below. Which paragraph, madam?
Paragraph 5, Lordship.
5.
5, on the ground that outsourcing of the armed guards small shall be contrary to the relevant clauses of the said.
5 and you write 5, 11. 5 and 11. 5, 11 and 13. 5, 11 and 13. Full stop. In view of the aforesaid observations made by the Honorable Supreme Court on an issue which is exactly similar, comma, the instant writ petition is allowed and the impugned award dated so and so passed by so and so is satisfied.
Lordship, one small submission. In para number 5, there is 2 clauses, Lordship, 31H and 31M. Here only 31H will be
Yes.
applicable.
It has been, it is clarified that before the Honorable Supreme Court, 2 clauses of the bipartite settlements were under consideration, whereas in the instant case, only clause
31H.
31H
Yes, Lord.
is under consideration.
Highly obliged, Lordship.